Oh, it's not going good for Connor.
All right, we are live, I think, on YouTube alone, because I think I forgot to put the Rumble and Locals link. So I'm going to be scrambling to do that while we meet our new guest, Andrea Burkhart, who I've exchanged with on Twitter and have meant to invite to the show, and she's finally been able to make it. And it's wonderful to have you.
Thanks so much for having me.
Thank you. Can you give us a brief introduction on who you are, what you're about, all that good stuff while I tap dance?
Sure. So I'm a practicing criminal defense attorney in Washington State. I've been primarily doing appellate public defense for the last, 10 years or so. But I've also done quite a bit of trial work. And so I started my YouTube channel during the Johnny Depp trial. I had been mouthing off on Twitter for quite some time before that, and finally got, much like Rob here, got persuaded to take that jump into video land. So I do a lot of just like produced videos. I don't do a lot of streams and things like this. So I always enjoy the opportunity to be able to come on with other people who have those hosting skills that I do not.
Well, don't count on too many, as I'm sitting here going, okay, let me get this link in here. Do I have the link? Oh my God, I got to get the link. But I wanted to bring you on, especially because I believe you were actually in Idaho or in Washington, attending the Koberger hearings.
I was, yeah. So one week ago, I was there for the hearing on the gag order, and then a couple of weeks before that, I was there for the arraignment as well. So yeah, the hearings are in Moscow, Idaho, which is pretty remote unless you live where I am, which is also fairly remote and conveniently about 2 hours from Moscow. So it's not too hard for me to get over there. I've been trying to make a point of going in and getting that personal view of things. Obviously, so far, they've had the cameras in the courtroom. We don't know if that's going to continue or not. So it does take some of the pressure out of being there live. But at the same time, there's just little things that you kind of always catch, and just like the mood of the room, things like that from being present that you weren't going to capture on the camera. So that's been quite an experience.
Yeah, right before we started, Steve and you, I believe, were discussing how the defense attorney is kind of getting a lot of flack, and it's not necessarily fair. Can you guys both go into that?
Well, sure. I mean, it's basically what I have characterized as a hate grift towards the attorney, Ann Taylor. Just for some months, there has been what seems to be a concerted effort to really undermine her and her position in the case, her standing as an attorney. It started off with an allegation that she had a disqualifying conflict of interest because her name had appeared on record as counsel for one of the victim's mothers, Kara Kernodle. And so News Nation had gone and found Kara Kernodle, who has an unfortunately lifelong history of drug abuse and addiction, quite an extensive criminal record. At the time of this interview, she had a warrant out for her because she had been charged with possessing drugs shortly after these murders happened, which I think is something a lot of people could sympathize with. You would probably relapse under those kinds of circumstances. But anyway, so they conducted this interview with her where it wasn't good. She doesn't look good. She's in a car where it kind of looks like she's living, just not a very good scene. But she makes all of these claims about how she felt so betrayed because Ann Taylor had done all these things for her. She had even given her power of attorney to help her get into rehab. Very, very sad story. Well, as it turns out, basically none of that is true. Having gone through like the records of some of her prior cases, you find that Ann Taylor is the chief public defender for Kootenai County. Kootenai County is the largest county in northern Idaho. So her name is on record for pretty much everybody, that's going through the system in that part of the world. And as it turns out, they had never even met in person. And Taylor didn't become counsel for her until after she had already, been on warrant status. And so they'd never met, never had confidential communications or anything like that. So that was a story that got ginned up into, it culminated in like a change.org, I think, petition that one of these commentators created to try to get her removed from the case. Just kind of crazy stuff to me. Then there was a story that came out about the funding arrangements, because this case is happening in Latah County, Idaho. She's the chief public defender for Kootenai County, Idaho. She's keeping that job, so there needs to be, some kind of arrangement between these counties for how those costs are going to get picked up. So the contract between Latah County and Kootenai County was made public, and it had all these details in it that Kootenai County is going to be paid $200 an hour for her work, and then overtime beyond that. Well, again, some of these same commentators now are taking this contract and turning that into somehow Ann Taylor personally is being paid an enormous amount of money for taking on this case, which is just blatantly not true. It's completely contradicted by that contractual record. But
$200 an hour for a murder defense?
Yeah, for a capital murder defense, which in fairness, that's the rate for the CJA panel and federal
CJA rate?
For capital. But it's not exactly an enormous amount of money by lawyer standards anyway. So it's just been this ongoing, like I said, it's a hate grift. It's this campaign to just really denigrate her and bring her down and question her qualifications and her ethics for no obviously apparent reason, because so much of it seems to be, quite frankly, just fabricated.
Wow. Now, when you're talking about the money, Rob and Andrea, that literally is when you're paying the office. You're not paying one person X amount an hour. So you're having to pay for the lawyer, for their staff, for their all these different things, right?
Yeah, 100%. Your insurance, your overhead, your rent, your phones, your computer systems, your research subscriptions, your malpractice insurance. All of that stuff is coming out of that $200 that you're getting paid.
And for a murder defense trial, that is a drop in the bucket. Like the number of hours that get put into this trial are just incomprehensible to the average person.
And what Rob mentioned is important, is this is a potential death penalty case. So you have to be a death penalty, however they certify defense attorney out there. And that's why she has to come from a different spot, right? There are not many of those. So she has to probably shove all the rest of her practice aside to take this assignment on. There aren't that many people to do it. She has to keep her qualifications up even before she gets this case, I think. And she hasn't done anything unprofessional. Everything she's done has been professional. And I'm on the other side of this case from my personal opinion. So I think it was terrible. All the things Andrea is saying is exactly right. And even worse when you read the trolling comments and stuff. She's done a very professional job, in my opinion.
Mm-hmm.
Okay, so you're talking about on the other side of the case. Are there people who are saying Kohberger's innocent?
Well, so let me comment on that, because what Andrea brought up were some specifics against Taylor that were ridiculous. Okay, but there's also just a lot of nonsense. There are a lot of people who talk first, understand never, and so that is on both sides of this case, and that includes the police. It's all fraud. The DA's fraud. The judge's fraud. The first and worst, I think, was Taylor, right? But on the internet, you're always going to have some, because she had a victim's family member talking about it, and that spooled it up. But there are people in all these cases that act like they know something that they don't know. And I take it that they're all acting in good faith until I see something different than that. And it looks that way for me, for the DA and the defense side. And they've worked in collaboration where they can. They fight where they need to. And that's how it's supposed to work so far. And I hate gag orders generally, but here kind of become a fan of gag orders because of the nonsense surrounding the trial.
It's so true. I never expected to be an advocate for a gag order in a case. Like, I never thought I would be defending that position, but it's just gotten so off the hook.
Go ahead, Rob.
Oh, I said the judge hates the term gag order. Listening to the hearing, the attorney that was advocating for the media jumped in and said, we're talking about the gag order. The judge cut her off and says, well, first, that's inaccurate and a very derogatory term for the order that actually is just a non-dissemination order. I'm I'm kind of on a middle ground with that. I think that this judge, I was happy with the hearing he had in the afternoon that was showing a little bit more kind of respect for there is the First Amendment right and principle here. We do have a balancing act we have to do. I think I just really wasn't very impressed with Shannon Gray when he was arguing for the Gonsalves family to be able to, go out and speak. He just dropped the ball. This judge has been fine, in my opinion.
Mm-hmm. Yeah, I've been a big fan of this judge, really from the beginning. Back in January when I, saw this case, and so I knew he was going to end up being the judge because there's only one option. It's going to be him. So I did a little research into his background, and I made a video on that. It's on my channel if folks are interested. But so he's got a good background for this type of thing. He seems to be a very measured guy, very well respected in the community. I really like his demeanor on the bench. He's got this great combination of being just extremely respectful and deferential to the parties, kind of letting them drive the train, if you will, about how they kind of want to proceed, how they want to put on their evidence and stuff. So not a real micromanager or, top heavy or anything like that. But at the same time, he's really not a pushover. I mean, like Rob is saying, he will say what he thinks from the bench. If he doesn't like you saying gag order, he's going to tell you, I don't like you using that term. So I'm impressed with him so far. I think from the defense standpoint, quite frankly, if I were the defense in this case, I'd be thinking real long and hard about if I want to even try to change the venue in this case, because he's a gem, and you run the risk that you're going to end up with somebody who maybe isn't quite so middle of the road, quite so even keeled. If you go and try to move it somewhere like Boise or Kootenai County.
I think it's worth pointing out in this case too, this non-dissemination order, which is the better term for it, as Rob says, that was an order that the defense wanted as well as the government. Because some people think it's just the government trying to do things in secret. In this case, the defense asked for it too, and it is appropriate in some cases to ensure a fair trial. Also, sometimes protecting witnesses and things like that. And non-dissemination before the trial occurs is different than when the trial occurs. It can be changed as it moves along. But this was not put onto the defense. This was something that they wanted as well, I believe. I believe in the terms that they have it.
Tiny bit of pushback. It was a consent order that was agreed when there were two parties to the discussion. That's fine. But generally speaking, the judge, when a judge gets presented with a consent order to seal a record or for a non-dissemination order, the judge is supposed to act as a backstop. The judge is supposed to inject himself and say, I have to do a balancing act, even though you guys might not want it disseminated. I have to make sure that the courtroom doors are still open to the public. So that was a little bit of a mischaracterization, but once the media interveners came in and started arguing, it sorted itself out.
Yeah. Sorry if I said it wrong. The point I'm really just trying to make is that it wasn't pushed onto Koberger's team. But Rob, your point's a really good one to bring out too. Thanks.
Okay. Anything else on that? On the case overall? I mean, there was so much swirling around about other crimes and Pennsylvania and different things. I mean, is there any meat on that bone, or is it just a bunch of speculation to get more grift?
At this point, it looks like most of it is just speculation and, a lot of anonymous sourcing that really isn't unreliable. I think what you're referring to is there was a story within the last couple of weeks that came out that said that his parents had been subpoenaed to testify in front of a grand jury in Pennsylvania about some unsolved, it was an unsolved murder or missing person or something like that case. And so this made a big splash because, yes, everybody kind of like Steve, I think, thinks, whoever did this is clearly a monster. It's hard to imagine that, this would be the first time that they did something like that. So looking for that sort of breadcrumb trail of other crimes that the person might be involved in. So really feeding into that narrative. Well, then the police department, who is in the county where they're running this grand jury investigation, then has to come out and make a public statement saying, we have no evidence whatsoever that he is involved in this crime. And so that was just kind of, it was ironic that happened, I think, in the lead up to this hearing on the gag order, just because it was such a good example of the kind of practice that the media is engaging in, and just the potential that has to really, really distort the perspective of this guy and this case.
Yeah, and I on that note, I've noticed, and I haven't gone deep into it. Supposedly, he is a giant fan of Ron DeFeo, who committed the Amityville, family slaying, and BTK's daughter has been coming out saying, "Hey, they're pen pals. They're just regular sweethearts." Is there any truth to any of that, or is that all exaggerations?
It's so hard to tell. We know that he did study under a professor whose name I'm forgetting now, but is one of like the preeminent scholars with BTK, wrote like a definitive book about BTK and his killings and stuff. But BTK himself made a public statement saying he's never met or spoken with Brian Kohberger. So again, it's just, it's like the telephone game. People get ideas and maybe things get distorted. And when there's a national voice being given to those kinds of claims, it's just so hard to sort through all the noise.
Cool. Now I want to switch gears so he disappears. What's up, Hayden? I was literally going to travel down under. I sent you an article about a case, I guess, with somebody who was just released, and it looks like it might be a really interesting case overall. Do you know about it?
This one's basically being compared very highly to the Chamberlain case. So Kathleen Folberg was put in jail for 20 years for murder and manslaughter of her 4 kids between 89 and I want to say 94. The 4 kids, they were all under the age of 2. Sorry?
Lindy Chamberlain?
Yeah. It's been compared to it because of everything that's sort of happened around it, because so they called her the worst serial killer because she allegedly killed all 4 of her children. As it turns out, there's been various inquiries over the last few years. In 2019, they still gave some fairly significant circumstantial weight to the reason that she was originally convicted was her own husband became convinced that she did it, basically, and handed over her diary to police in 99. They split up in 2000. Because in that diary, she had talked about her guilt over their deaths. And basically, it was, from the sounds of it, it was a woman that was very badly going through not only the loss of her children, but postpartum depression as well. And they've taken that, used it as evidence to say she must have killed them. Now, as I said, there were various coronial inquests into the actual circumstances around the death. The last one started in, I believe it was 2020. It's just finished up. And they found that 3 of the kids, so the daughters, had a very rare genetic disorder that was able to basically, not quite SIDS, but very similar. So they think that the genetic mutation that the daughters had led to sudden cardiac arrests. The son had a completely different genetic disorder that caused epilepsy. And in the months leading up to his death, he was having epileptic fits. And so basically the retired judge that was overseeing the inquiry has found that there was reasonable doubt. And she spent 20 years of her life behind bars. And they've just found now that there's reasonable doubt. And so the New South Wales governor has given her a pardon, but it's whether or not he's going to refer it back to the Criminal Court of Appeal for her to actually have an acquittal, basically. And if that happens, then she can turn around and sue the New South Wales government for false imprisonment for 20 years. Wow. So it's going to be very interesting to see exactly how that pans out. Personally, my own opinion on it, given that there were so many inquiries and it was only this most recent one that found that there was reasonable doubt, I don't know that I'd be doing it because she's out. She has her freedom at the moment. Whilst it would be brilliant to have her name cleared, I feel like there's every chance that it would go against her and she may wind up back. I mean, she's got the full pardon, but just I don't know that there's much to win, basically, is what I'm trying to say.
Correct me if I'm wrong, but Lindy Chamberlain, she was acquitted originally and then they recharged her and convicted her. So the double jeopardy system is not the same in Australia or the UK. Very different. The Crown can appeal and then win the appeal, and now you're charged again. Or
even after pardon?
Wow.
No, so the pardon itself won't be the pardon itself. I mean, she'll remain out of jail, but I don't see much of the reason to go back. But as you're saying, Rob, yes. So the whole thing about if the prosecution applies to a higher court and it's found to be an error of law, they'll send them back even if it's an acquittal, and it can be completely retried. Yes.
Wow.
Yes.
I think that's what happened to Amanda Knox too. I think we might be a bit unusual here in the U.S. with our double jeopardy restriction.
But the Italians, they operate under the continental system. That's a Napoleonic setup, so that's a whole nother mess. Yeah. But yes, we're generally the only people where it's like, once you're done, you're done. So.
Wow. But I just wanted to double check. So if the person's been pardoned and they're free and then they retry it, does that mean she'll just be
she could still be
convicted?
Found guilty again?
But would she be convicted?
But she'd have her freedom.
Okay, so it would just be a stain on her record.
Yes.
But Lindy, it's not just Eric. It's not just a stain on her record. Lindy Chamberlain, the news media still goes out and bashes. I think 2014 there was an article, and the only reason I know this is we covered it in Trials of the Century. 2014 there was an article where a dingo stole a child and had to wrestle it back. And in 2014, CNN and all these other major media headlines were running articles still talking about her and still blaming her, and then throwing shade at the fact that she was ultimately pardoned, but it wasn't a full acquittal.
But it was a meme, wasn't it? I mean, that one got so bad. It was a dingo stole my baby. It was like a comedy routine.
That case.
I mean, the problem with that case is there was significant forensic evidence to prove that she had nothing to do with the death of her child, because they had later found, they had gone into the area, I believe in Ayers Rock, they found the matinee jacket that the baby had been dressed in, and they found dingo saliva on the jacket to prove her story.
And then there was the climber that fell. So that's what led to her ultimate acquittal. There was a climber on Ayers Rock who ended up falling. You're not supposed to be climbing it, period, but ends up falling. And they have a search party going out looking for this climber for a long period of time, and they can't find him. Well, ultimately they find a dingo den, and they find bones, and they find human remains, and they identify the climber. Well, what else did they find in there? But they found infant bones, and they found, I think, the shirt that was missing, or the little onesie that was missing.
The onesie.
Wow.
So they literally found the body. That's the level, and it was by happenstance because a climber fell.
Wow.
I didn't know that.
I didn't either.
Maybe the
she's
dingoes
not
are being
guilty.
framed.
She lost her baby and gets to be continuously tortured in pop culture. What a trip.
Yes.
She also had to be pregnant in prison. I believe she was pregnant with her second daughter. She gave birth. That child was taken away from her. She was in prison for how long before she was
20 or 30 years
acquitted?
Wow.
It's very sad.
Okay, so I mean, not only is everything going to kill you in Australia in terms of animals and plants, but also the court system.
Yeah, then you're going to go to jail for it.
God bless it. I had a friend who lives in Cairns, and he was telling me about the sharks that are in there, that kept swimming in. And I'm like, oh, that would freak me out. He says, oh, don't worry, the crocs get them.
Yep.
And I'm like, and I'm just sitting here going, well, wait a minute, how is that an improvement?
That was not comforting at all.
Well, he had a good comeback. He said, but I still feel safer here than Chicago.
No, well, I mean, up in Queensland, there's a very specific golf course. They had a flood, and so now the water traps are home to between half a dozen and a dozen bull sharks. So no one's retrieving the ball out of the water trap there.
No, wow. I've seen videos from that. That looks awesome. Scary, but awesome.
But yeah, no, honestly, to be perfectly honest, I do feel safer in an area where I know that there are crocs, because you're going to have less sharks. And for the most part, if it's a sunny day, the crocs are going to be laying out on the bank. You're going to see them for the most part. So as long as you don't do anything stupid, they're not coming. You're not going to lose a limb. It's the idiots that go out there that lose limbs and their lives, honestly. So
Darwin Awards. All right. So
Americans would do it.
Oh, for sure. Steve, I sent you a filing earlier. I didn't know if you had a chance to look at it. It's on the Rust case, and Hannah Gutierrez Reed is still being charged, even though the Alec Baldwin charges have been dismissed, but not with prejudice. They are supposedly doing a deep dive investigation into the quote unquote tool marks that the FBI somehow managed to miss. This new prosecution team, they're a crack team. They're taught by Hilaria Baldwin on how to look at a gun, and somehow they're better than the FBI. they found these mystery tool marks and are doing deep dive. So Alec Baldwin at the moment is off the hook, but he could still be refiled if it was within 60 days. Hannah is screwed at the moment, and they're saying more. I believe that she was hungover, and I have texts that went back and forth about the situation. So Steve, can you fill us in on legal aspects and what I'm missing?
Well, I did read through it quickly, so I'm not an expert on it. I didn't read the primary motion, just the response to it. So let's get into one side of it. But it was quite long, and at least according to the state, her attorneys filed everything they could to attempt to obtain a dismissal of the case. Well, why not, right? And especially since Baldwin's out of this thing. So one of the things they said was the first information or indictment filed against her was filed by these old district attorneys. They had these political situations. The wrong person signed it. But the state says, well, yeah, but we filed a second one with this new team. And this new team is not the same as the old team. In fact, look how independent we are because we dropped the case against Baldwin. So that shows that we're independent, free thinkers, willing to look at new evidence. There just wasn't new evidence for Reed, they say. And they did kind of slam her there, saying she probably was drunk or high at the time. If they don't know that, I don't know that they should have been saying that in their response. It seemed to be just kind of slamming her. She also said that, look, the state made a lot of comments outside of court that are prejudicial to me, and they're not supposed to do that, which they aren't. But the state says, look, we just talked about the case in general, nothing against you in particular. And by the way, your team was on the media everywhere they could be, making up stories about intentional sabotage by some other staff member that there's no evidence of. So they also said, look, we got the new prosecuting team in place before there was a preliminary hearing. We've reviewed this evidence. We've met with you. There is no indication that these new people are biased, they say. And so just the fact that we made a decision not to prosecute Baldwin right now, offered a deal to somebody else, that doesn't control your case. It's like when you get pulled over and you tell officer other people were speeding faster than me, that doesn't get you off. That's kind of the logic there. But I don't know if there was legal merit to any of the things that her team brought up, because I haven't read their brief or looked at it. But that was kind of the back and forth going on. It was a little nasty in there, the things that they said about her. But I would doubt she'd get her case dismissed as long as they did all the things they said they did, which was bring in this new team and file a new information and go forward from that basis. I don't know. It's possible somebody else has looked at it and has a different take than I do, with more experience in this area, because you have so many great legal minds here. So anybody feel free to correct me or amplify.
Anybody else following it?
Yeah,
that's all I know about it.
I mean, when it comes down to the tool mark examination stuff, that is a lot. I think we heard about in the Murdoch case. It's an art. You look at a scratch and you try to figure out what's there or what's not there. So this idea that the FBI may have missed something, I mean, it's very likely because it's all subjective. You're going to say, oh, that scratch looks similar to this or looks similar to that, or it's consistent with this, consistent with that. So it's not a surprise that that's an issue that's come up. I do think, though, and Eric, you were mentioning those things about Hannah being hungover. That, if that's true, yeah, things are good. That's not a good look for her. I mean, that's really bad.
Right. That would bring him to the negligence, right? Because if she was not up to, also there were claims that she was smoking weed. And I think there are federal firearms restrictions when it comes to taking substance, even if you're not doing it at the time, just at all. I believe it's illegal. I'm not the expert there. So I'd have to.
You cannot consume marijuana and possess firearms under federal law.
And so what this tool mark thing here is what the gun might have been modified or something like, because usually tool mark analysis usually occurs when you recover a projectile or a casing or something like that. But it is, as you say, it's got a lot of subjectivity to it. It's often attacked by defense rightfully because of that, right? So I guess if they're saying, well, the FBI missed this, well, it is something that could be missed. I don't know what they're trying to do here, other than say maybe the sear was filed down some and that so it went off.
That's what they're trying to say. But here's
that's hard to miss, though.
The FBI broke it, though. The FBI broke it. So how do you know that it was modified before the FBI was testing and breaking it? It makes no sense. How can you claim that?
Now, I will say this. What the state said in their motion was that particular issue should be the subject of a motion to suppress or exclude that evidence, not to just dismiss the case. They're saying if you have an issue with this evidence, move to throw that out. Yeah.
I think that's
yes. I
correct.
mean, they get to ask for their remedy. If it's a misconduct, type of argument or a spoliation type of argument that they're making, then they're justified in asking for dismissal. Doesn't mean they're going to get it, of course, but they can ask for it.
So help me figure out the tool mark thing. I'm still saying that. The FBI went in and tested it. They tested it so hard because they were asked to do the complete testing. I'm waiting to hear back on who asked for it because it was beyond normal testing. When they were doing this testing, which I believe took all the way to a hammer on the hammer, so to speak.
Yes, they did.
And broke the gun. How the hell can you tell me that it was modified before the FBI tested it?
I think that's going to come down to just seeing because we don't know what the internals look like of that firearm. Also, I guess I would just chalk this up too. I mean, the feds are government employee. They're government employees, number one, and just number two, people do miss things. People do mess up. So it very well could be something there,
or could have been.
It could have been. And
it's like now, but we're chasing a phantom, in my opinion, because somehow they didn't see it, so they didn't see the thing that could have been there, but we don't know if it was actually. That doesn't make sense. And if that's the case, and you're saying it's definitively modification of the gun, hung over or not, why is Hannah being charged? If you're saying it's enough for Baldwin to slip out, the well-heeled, well-moneyed, super powerful, well-connected, Democrat leading guy, somehow his charges get dropped, but then the individual who is barely getting by, borderline homeless at any point, has very little defense. Yeah, we're going to keep charging that one. Does that make sense? Does that seem completely fair?
Those are two different questions, Eric.
Yeah.
Answer them one at a time. Answer them one at a time.
Does it make sense? Yes. The state has to expend a significant amount of resources with significant risk to go after Baldwin. You have a competent defense team that shreds every motion that gets filed. You have multiple attorneys taking on prosecutor's office that's overstretched, under budget. So, yeah, that plays into whether charges get brought. Now,
they got a whole new budget, though. They got $300,000 specifically just for this.
That is nothing. That's
nothing
still,
to go after. You'll burn through that. Yeah, you'll burn through that so fast. And Alec Baldwin can do that 30 times over.
Yeah.
Oh, sure he can.
Alec Baldwin got to take advantage of what, from my perspective, is just a total problem with how the gun handling regulation stuff works on the movie site in the first place, because we all know, okay, this was in response to the Brandon Lee, and they needed to have tighter restrictions so that things like that don't happen on set. But the problem is that they have so thoroughly diffused the responsibility for firearms on the set now that you can't attribute it to any one person. Everybody gets to kind of pass the ball, pass the buck down to the next person because they have all of these stopgaps, right? But so then what happens when every single person in the chain, fails to live up to their obligations? There's no one person you can hang it on. So I think that's part of the problem here, is that you kind of have to charge everybody or you have to charge nobody. I think that Alec Baldwin almost certainly got exited out because of the difficulty they were going to have establishing a duty on his part, given that, they can show, okay, here's what the armorer's responsibility was. Here's what the assistant director's responsibility was. We can show, as a matter of like negligence per se, that they didn't meet the standards that are applicable on movie sets, but you can't do that with Alec Baldwin, at least not in his capacity as the actor, who's pulling the trigger. They'd have to, I think, be looking at him as one of the producers, as somebody, who has kind of the ultimate responsibility for why everybody on this set apparently couldn't manage to do the things that they were hired to do.
Exactly. And when you have people cutting corners, they're going to New Mexico specifically because it avoids certain kinds of rules and regulations that you would have in Hollywood, like in California. It's a recipe for disaster. And the problem is that you're right, Andrea. There are so many individuals who that decision has to go through. There are so many people, I've grown up in and around the film industry. There are a lot of different people who There's a reason why this doesn't happen and why it's rare, because there are so many checks and balances, because there are so many people to answer to, because of the liability, because nobody wants a lawsuit on assets. Nobody wants to be involved. Nobody wants to be invoked. And so you're right. There are a lot of people that you could charge, but it is a good question. He has more money to throw at this defense. He does have a different degree of responsibility than specifically somebody who is an armorer. So it might look a certain way, but an armorer does have a slightly elevated degree of responsibility for something like this.
I guess where it gets problematic, though, too, is we have an entire chain of command or chain of custody issue, too. So you have an armorer who's not allowed to be there because of COVID protocol. So she didn't actually hand him the gun that one time. That was the one time the assistant director actually supposedly handed him the gun. Of course, it depends on which testimony you get from Alec Baldwin, because if you watch his original interrogation, he did say that Hannah handed him the gun every time, always Hannah. He said, quote unquote, always Hannah. Somehow that changed to, oh yeah, well, it was Dave Halls who did it. So now you have an armorer who can't supervise what's going on there, a first AD who's handing the gun. So I don't know if I'm wrong, but I feel like there's some diffusion of responsibility and problems, not to mention the 2 jobs that Hannah was supposed to have, and the criticism that she was spending too much time being an armorer and she needed to get back to the other props. I literally broke that letter. So,
which is why you should have 2 separate people doing props and armory type stuff on a set, so that nobody gets overwhelmed, because the job of an armorer is very important in case something like this happens.
Which is why the producers should be prosecuted. Just saying, that's why are we not talking about that? Why is that kicked out? That's the part that's driving me nuts about this entire story.
Ms. Pickle, Gabrielle Pickle, very specifically, the line producer who was complaining about Hannah. I mean, and this was a fight. Again, I had the emails, broke them. Okay, so, well, I guess we'll see. Go ahead.
Well, no, what I was going to say, Eric, is ultimately, it does, there's some diffusion of the responsibility, but you already have David Hall already pleading out. He's already pled out to a misdemeanor charge there.
Yeah, the irony is that if Hannah does squeak through in the end, then the only person who actually gets convicted in any way is the one who took the deal.
Yeah, but that said, though, I mean, there is some diffusion of the responsibility here, but that party also got charged as well, so it's not as though it's just Hannah Reid on her own, but I mean, it does feel that way, I think.
But couldn't her defense say that? Hey, the guy just pleaded. He did it. There you go. You got your person. Move on. You're letting Alec off. He actually pulled the trigger. I've got somebody here who couldn't be over there supervising. By the way, I'm not trying to defend Hannah in of itself. I think there's responsibility all around here. I just don't like seeing one person with a means who actually pulls the trigger, sliding away, and quite literally the weakest person with the least support, the easiest target, is getting nailed to the wall. That's just how it looks to me.
Well, and he was responsible for hiring her as well.
Like. Sorry. It's not what it looks like to you. That's exactly what's happened. So, that's just the nature of the system, sadly, in America.
I mean, a lot of people are saying, oh, well, why did you have this 20-something-year-old armorer on set? Well, who hired the 20-something-year-old armorer? Who vetted her? Who looked into her to see whether she was qualified? Who made sure that she would be responsible for something so significant? They could have hired somebody else. That is production's responsibility.
Supposedly. Everybody else turned it down. And the problem is that her father, Estelle Reid, who is one of the greatest armorers in history, gunslinger, and that's part of that's causing issues with the case, is that he is a trick gunplay expert. I mean, literally maybe the best in the world. He's getting old now, so he can't move it. But if you watch video of him, he went all the way back to Ed Sullivan's show, but you could just see, I mean, he's just he would work the guns like they were spinning like fans in his hand. And just the play he could do with guns is staggering. And he took her around, so she kind of half grew up later on sets with her dad. So we have a nepotism angle that has, come into it.
Well, nepotism is hardly new in Hollywood, Eric. I mean,
no, and it's not always wrong, by the way. That's the weird part is I think that there are many arguments that nepotism could be a good thing if a person really does get qualified. You know, they're exposed to it their whole life. She could have been, and she did work the film with Nick Cage, The Old Way. There are questions on how that went down, but all the actors who were involved said no, she was pretty good. There was no problems. I think Nick Searcy has come out and said she was great, no problems. So I don't know. It is a weird one, but she also was very cheap.
Well, we also heard that she was, you know, doing things like tucking guns into her waistband on the set, and that they would go and just like shoot stuff after, you know, the filming was done.
The opinion is false. Hold on, I got to put it out there because I talk to Seth all the time, and he's.
I heard things. I could be wrong.
Oh no! That was a rumor. That was out there really early on about the plinking.
Plinking. Yeah, they were out plinking.
And from what I understand, like from Seth Kinney and from others that know, that did not happen.
Oh, interesting.
It was not. So
okay,
that's good to know. I'd rather not perpetuate false information. So thank you for clarifying that.
Yeah, I thought that was actually true as well. So
yeah, I thought it day one, and I heard that she was young and like the young female, that she was I mean, they smeared her name from the jump.
Well, they probably hired her because she was cheap.
She was cheap. Yes, that's exactly why they hired her. They couldn't get any other armor, and I mean, they were so cheap. It was like, okay, we're going to hire you for this, and to make up the money, she got a second job on props to try to cover more spam because she only had so many days in to do the armor work. So it definitely was a
is that a union thing? Just out of curiosity, is that? Do you know, Chandler? Is that? I mean, I'm assuming her rate is set by the union, and it's going to be based on her level of experience and stuff like that. It's not like she can go in and charge, you know, what the market would bear for a job like that.
I actually don't know what union she would necessarily be a part of. There are lots of different unions that cover different types of players in film. So you have IATSE, you have, you know, SAG-AFTRA, you have the directors union, the writers union. I don't know she was unionized. She should have been, but she might not have been. So if there's not a union that's covering it, they're going to want to hire a non-union person. And also, if they're doing the film in New Mexico, there are different rules and regulations that do not require them to hire somebody who is union to be a part of that project.
Not union. As a matter of fact, Dave Halls is not union.
Right.
Well,
so
interesting.
When you're hiring people who are non-union, you're doing it because there are fewer protections. You're doing it to cut corners. You're doing it so that you don't have to pay them as much, and that does create problems. So if she wasn't union,
question on this one: if she was union, do we think the prosecutors would have paused a little bit before prosecuting this? I think they would have. That's a heck of a lot of resources that they're going against.
Good point.
Well, what do you mean, Rob? I'm trying to.
So in weighing the determination of whether to proceed with the prosecution, they're assessing essentially the cost of the entire prosecution. If she's engaged in union activity and the union has to front a defense, that's a bunch of resources that they can pour into hiring a defense attorney. The prosecutor knows that going into it when they're assessing whether or not to charge it or how to charge it, and they charge it with like a negligent handling instead of the negligent homicide.
Well, the thing is, I don't think she would have been hired if she were union in the first place. I think I think the setup is such that they are looking for cheap labor, and that is how you cut corners. That is how you get to this problem. That is how you set this up so that this accident happens. It is the cutting corners in the first place that creates this problem. I'm not going to say this never would have happened in California, but it never would have happened in California because there are so many protections, and it is a requirement to hire union people. They went to New Mexico so that they didn't have to do that.
Yeah, I mean, they did not have a big budget on that movie in any ways. I mean, and Chandler, you can confirm this later, but I believe the whole armor position is squirrely anyway, because it is just a part of props. It is literally a props person with a specialization, from what I understand. And so there's no breakout saying, oh, the armor. And even Baldwin has done in his statements that a lot of times the prop master is the armor or whatever. They just get extra training. And that might be part of the problem here too. armor being a specific term. He even said, I never even heard the term armor.
That
was a new term to me.
Well, it's not something that's going to be
yeah.
on every film, because you're not going to have props that are weapons in every film. You're
Sure.
only going to have weapons as props in certain kinds of films, and not every film will be shooting in California. Sometimes they'll be shooting in places like Toronto, or there are lots of international shoots. And so it's a good question, because the thing is, I worked as a legal assistant in entertainment law for a while, and what we would do is, part of my job was I would go over contracts for every single person that was attached to every single film, and catalog all of those contracts. It's that was my first legal job ever, and we almost never had any paperwork for armorers for any of the projects that we worked on. Now, mind you, I only worked at this law office for 8 months, but I worked on upwards of, I'd say, probably 10 films, and we didn't have any armorers attached to any of those, because it's just either you have somebody who's working with real weapons or you don't. And so I want to look into it specifically. I actually can't answer the question as to whether armorers are supported by a very specific kind of union. I would imagine that it would probably be SAG-AFTRA, but I would have to look into it. But it's not something that it doesn't come up on every film, so there isn't a necessary designation.
Well, and I think that this hopefully will lead to a precedent to where they can really look into all the guidelines, how they worked out, how the system broke down, because the way they're written now and the way things were being followed, I don't know, obviously something bad can happen. It would probably be a good idea to follow into it.
Well, it's we discussed with the the Randall Miller with Sarah Jones and that death with the Midnight Rider incident, which a lot about, and I was really impressed with with your knowledge. It's it's the kind of thing that the idea of precedent, it exists with California laws and with labor laws and union laws, and that's the legal system in California is such that entertainment is covered in a way to prevent accidents like that from occurring. It's when you go to other states, it's when you try to to cut costs, that things like this happen. And I just think that in general, it's an unfortunate cautionary tale to anybody who wants to make a film for a lower budget. And, and cut corners.
You brought up Midnight Rider, which leads into one thing. There's one person who has skated this whole time, and Midnight Rider is the perfect precedent for it, and that's Joel Souza. Yeah. Because he got shot too, everybody overlooked, but he was in charge of the set. It was his movie.
Yep.
Now, Gabrielle Pickle, yeah, I agree. That producer, she should be looked at, the line producer specifically. What about the damn director? Sorry he got shot, but see, he was smart, I feel, because he got shot, got treated as a victim, but technically he was a person responsible, in my opinion. And because everybody's worried about his being shot and his being smart enough to keep his mouth shut, unlike other people, look, nobody's ever charged him. Nobody's ever talked about it. Versus Midnight Rider, who served time in prison, hard time.
Randall Miller. And if Randall Miller had been, if he had been hit by that train, if he had lost a finger, or part of his toe or whatever, would anybody have, necessarily? Maybe yes, maybe no. But that's a very good point, Eric. I hadn't thought of that.
And Eric, I still say this now, and I've said it before. Had Hannah and Alec Baldwin, everybody had just shut their mouths.
Oh yeah.
This would have we would have forgotten about this by now.
Mostly Alec. Hannah wasn't out there talking. Her lawyer did do a little bit because I think he saw it coming, almost in response to Baldwin. But then you're saying that Dave Hall shut his mouth and he wound up taking a plea and he's been charged.
Well, but them talking, but when Hannah and Alec talked to the police and everybody else talked to the police, gave them the information. Yeah. So had everybody just shut up, nobody talks, everybody walks. That motto exists for a reason.
Okay, perfect. On that note, to close that subject, let me see who has a subject they want to go into. I'm going to go with Rob. I think Rob's tighter on time today. So, is there anything you wanted to?
I would like to hear from Joe. I've got the eye candy sitting beneath me. I want to hear from Joe. I've been chiming in all over the place.
No, I'm sitting here with rapt attention. I'm waiting for my spot, and then I'm just going to jump right in. So, Rob, you're short on time. I appreciate you weighing in, but
I haven't been covering too much this week. The LIV Golf thing was funny. So they announced the merger, and the absolute piece of garbage that Jay Monahan is suddenly creates the PGA finds a medical issue that he's dealing with, so he's no longer performing his duties. But they announced this merger between the two largest entities when there was already an investigation into monopolistic practices by the PGA. They then say, no, we're just going to become one big entity, and they think the DOJ is just not going to look. So DOJ this week announced that they're starting an investigation into the merger. So we'll be seeing what happens of that. I think that there's a lot of risk. These guys are playing a game with their 501c6, and I think Congress, it's been long enough. Take a look at that code provision, man. Start revising what these not-for-profits can do and how much money they can really funnel through them. It's kind of a joke.
Cool. I'm so clueless about it. I know Steve, he studied up for it for last week, but is there anything else going on? I mean, they just did a merger, and it sounds like they're going to be rich.
What Rob said, the guy had said, as long as I'm director or heading PGA, nobody who takes this LIV money is going to play these events. And now he has the sudden medical emergency.
He invoked 9/11. He invoked 9/11.
no.
Yeah, he did.
At the RBC Open, he invoked 9/11. And he basically says, on this particular day, it was on September 11th that weekend. On this particular day, we remember those who were lost in the tower. And for me, being friends of two people who had lost family members in the towers, all I have to say is, you never really have to worry about your image when you play for the PGA. Have you ever had trouble sleeping at night playing for the PGA? Implying that the people that were playing for LIV Golf, maybe 9/11 and the towers had to do with it. And then immediately goes out like several weeks later and says that LIV is this phenomenal investment partner, and says that in a direct quote, like this brilliant investment.
Isn't that borderline defamation, what he was saying before?
He skirted the line with a lot of it, and it's going, don't blow smoke. We know the PGA takes money from all types of different entities that have investments in all of these different shady deals. You want to talk about sports washing? Every enterprise does it. NBA, NFL, PGA. I don't care who you are.
Yep.
Don't stand up there and pretend like you are this beacon of morality when you're not. Just, it's a joke.
Especially not when you're about to merge with the other side that you're saying you're so holier than.
Yeah, I mean, those are strong statements, because I mean, we already have Congress people who are smart enough to not say that the Saudis were behind anything like that, and that's kind of the implication. It sounds like he was laying out, which is very, very dangerous. And you're right, Rob, but almost could be taken as specifically the individuals who are funding LIV were funding such other things. That's, I don't know. That
was
seems
gross. It was really gross when he did it.
I don't know if his medical emergency is he got the bus backing over him from other people in PGA that made him do this deal, or from straining his shoulder carrying all the money to the bank that he got for going along with it. Something one or the other.
How about both?
Yeah.
Oh, certainly it could be both. Yeah.
Wow. Okay. Everybody's Joe. What's your rant? I like Joe on mute.
I like his Joe. I forgot to say this. I didn't get to say this yet. I do like your new glasses.
You're very handsome.
Thank you very much.
Very, very Falling Down-esque. If you haven't seen that movie.
Yeah, I know.
Joe by the end of the day is gonna have.
And he's, for those of you who are too young, he's making reference to Michael Douglas.
Good movie.
And yeah, I didn't see the movie, but I actually think it's a good look for me. So yeah, they actually called it. You don't want to hear about that, but yeah, thank you both.
Okay, I'm going to go to Sean. What case are you covering lately, or what are you focused on?
Well, it's very local to me, but there's I'm starting to focus on this. There is an attorney here in Cleveland. He went to go see his client at the jail, and when he walked through, you have to go through the body scanner machine. And he said, I got to go to the bathroom. And he ran to the bathroom. And when he came back out, the guards were a little suspicious, so they went and checked, and they found some meth in the bathroom. Apparently, he didn't think to flush it, which come on.
That's wasteful.
Yeah, well,
I mean, he probably planted it there so he could go in, visit, and then go back out and then pick it up on his way out. I mean,
yeah, it's like a liar.
Yeah. Well, yeah, I know, he's hiding it. But so they take him and they take his phone, and then on his phone, they find cheese pizza all over it. Yeah.
How did they get into his phone?
Because they took his phone as evidence to where he got his drugs from. I think there's some suppression issues with that.
There's a warrant problem there.
Yeah. Well, I think eventually they did get a warrant. I don't think they just checked it right there, but they did take his phone. I think they got. Anyway, they found a bunch of stuff on it, and now he's going to be defending himself in October, and that's going to be televised. So that should be very interesting coming up.
He's pro se.
Yes.
Oh no.
Oh, he's sober.
Oh yes.
Well, that's as bad as there was a barrister that got struck off the roll recently for he was representing clients that were up for possession of narcotics. Like 2 weeks before the trial, he contacted them asking for them to supply him with drugs.
Wow.
Yeah, I haven't been able to cover as much lately just because I've had to go out and do like honest work during the day, which really cramps the grifting. So,
by the way, warrants issue that popped something into my mind. If you guys ever want to cover it, you should look it up. A little bit of history. But David Berkowitz, son of Sam, if he didn't confess, he very likely would have walked, because the warrant they used was after the fact. They looked down at his car and said, "Hey, that looks like a gun barrel." Then they searched his car.
Oh,
and then they said. And this literally happened. They said, close everything up and get that warrant. This is all on record. Then they got the warrant, but that car led into his house. I mean, everything came from that car and from that ticket. And it is theorized that it was a total, fruit of the poison tree aspect. And that if he didn't actually confess himself, you might have had the son of Sam completely free.
You might have. I hate to blackpill you on this one, Eric, but my suspicion is that what would have happened is we would have just gotten the inevitable discovery doctrine 60, 70 years earlier than we actually did.
Yeah.
What is that? So you can educate
Inevitable discovery doctrine is one of the excuses that is under federal law for a violation of the Fourth Amendment. No harm, no foul. If they would have found it anyway, then it doesn't matter if they trampled all over your Fourth Amendment rights. Because they could have done it right. They could have done it right, but didn't. But they could have, so it's okay.
Yeah, we all know where this is going, is what the court says. And then there's also the favorite 2-word phrase of every appellate judge in America: harmless error. Oh well, they're guilty anyway. Doesn't matter.
Yeah, only slightly exceeded by the AEDPA, which is, the procedural hurdle that you have to clear in order to pursue habeas corpus relief in federal court. And so there have been actually like a flurry of recent cases that have come out where they're just extremely strong substantively on the merits, like people have proof of actual innocence and stuff, but they trip up on this procedural bar to be able to get into court. It's kind of a long-standing, well-known problem.
Wow. Okay. And by the way, note to everybody, remember that I am dumb. I'm not a lawyer. So anytime, just present me like the dumbest member of the jury, and always explain whenever you're, bringing up any code or whatever, because I really have no idea. Let me go through a couple of these. Angie Torres, I guess, a super sticker. Thank you very much. Has anyone watched the TV show Jury Duty?
I've watched a little bit of it. It's actually pretty funny.
I've heard it was. I heard it was like Office for Juries or something, but I don't know.
It's hard to explain, but it's really good.
Okay.
I enjoy it.
This is going back to during the whole Hannah talk, but I can see where they're going a little bit. This is like charging a mechanic with manslaughter because a speeding DUI driver killed someone and their brakes weren't working perfectly. I think it's a stretch of an analogy, but I think it's saying that about the charging Hannah when he pulled the trigger ultimately, but I don't know. The part I hate.
Pretty damn different. That's pretty damn different.
Yeah, it's straining. But I will say one thing: the prosecution team, whoever they are, and the cops, everybody else just seems to have a substantial lack of curiosity in the most important element of the case. Where the hell did the live rounds come from?
Yes.
And we can move on to something else, but everybody seems to forget if you take every other element of that case and they were actual dummies, this is a non-incident. Nothing happened.
Well,
live rounds on the set killed her.
The state in their motion response says they're making Herculean efforts to try and find out where that came from. Now, I don't know that Hercules though did a lot of criminal investigations or tried very hard at that. I thought he was doing other stuff, so I don't really know what they mean by that, or if they're ever going to figure it out.
I mean,
but that's honestly, what they say though.
Because the road where this all, they got the ammunition from the Seth guy, right, Eric?
Seth Kenny, yeah. And I talked to Seth. Everything on the record, I do talk to Seth. He's the one who sent me the file that I gave to Steve. So I'm familiar with it. I've seen all the texts, and it's very interesting. They are trying to hem up Seth Kenny because of the tool mark thing. Problem is, though, they can't really hem him up, from what I understand, because when he sent the guns to the set, well, first off, he was out of town the day the guns arrived and went to the set. They came straight from the manufacturer. There's proof of that, directly from the manufacturer, brand new, off the line, no changes. And he had written beforehand handwritten labels to put on the guns, whom he suggested for each person. So when they went to the set, the guns, the recommended guns were for A, B, C, and D. Well, Alec Baldwin did not choose his recommended gun. Alec Baldwin wanted the biggest gun. I know everybody is surprised. Alec Baldwin wanted the biggest gun out of the lot. But I would say that that's a pretty strong defense for Seth Kenny in the sense of how the hell could he have been tied to it if he literally recommended a different gun, wasn't there at the time, it went to the set, and how would you work those chances? That's like 23-degree chess.
Yes, it's super rationality. I know he's going to pick the bigger gun. So that's what I'm going to do. I'm going to trick him. No, but that's my question about the Herculean efforts. It's a very short chain, so you know where it starts. It starts at Seth, but that's because he's the guy who furnished everything. So this idea there's Herculean efforts involved. There's only so many people involved in this chain to start with that I think, they're just stalling for time. I think in that regard on that topic.
Or maybe it's a Herculean effort to come up with somebody because we let Baldwin off the hook and it looks bad. Don't know, but that would take a lot of effort to make sure that we can pin it on somebody. What is it? The Saudi? Some other dude did it?
Yeah.
Yes.
Oh, let me see. Okay. Jim Sadala. It's kind of like charging a cashier for locking the door so a thief can't steal and not unlocking it fast enough so the thief starts shooting customers. I don't know where these analogies are coming from.
That's an actual case. That's an actual case that's happened.
Yeah, that's up in Michigan.
Wow.
This is actually what I was looking at, but there's still more to it. A guy comes in, tries to buy stuff from a gas station at like 4 a.m.
$3 worth of stuff.
Yeah, it was like $4 worth of stuff, and this is one of the gas stations in an area where everything's behind bulletproof glass. Well, there's a fight and an argument, and the guy says, well, I'm going to take it anyway, so the store owner locks the door from behind the counter, which that's normal in crappy areas. So he starts, now this is where it gets a little murky, is the prosecution claims that he threatened to start shooting people. And the defense is claiming that one of the customers and this shoplifter were getting into it. Well, long story short, eventually the door gets unlocked, but the allegations are the gunman didn't know that, and he starts shooting people that are in the store, and then finally takes off because he was like, unlock the door, I'm going to start killing people. And then he still kills them all and then takes off, and they charge the store owner with manslaughter, kind of under the same principle Ethan Crumley's parents were charged with manslaughter. So, yeah.
Oh, ooh. That seems like a stretch.
That Crumley case is at the limits approximate cause of this thing sounds beyond that to me.
Oh, this one is, but the judge said, there's he had his preliminary hearing. He's going to trial in August.
Wow.
The judge is like, he did nothing but pour fuel on the fire. It's like, no, I'm pretty sure the guy who stole stuff and was willing to kill people poured fuel on the fire. But
what's the name of that case? Do you know?
I'll send you his information, Joe.
Thanks.
Yeah.
I'd love to talk about that one next week if anybody goes into it, because that's
it's crazy. It's a very weird story.
All right. Grimm's Bar here has to pipe in. Why are there no Irish lawyers? They can't pass the bar. Yeah. But for cash, I will take bad jokes. I have no soul. All right. So what case open for everybody? Joe, what are you covering? You're so quiet. Everybody's so shocked.
Oh, I've really been fixated on both
Trump indictment,
Trump and the Biden issue with the FD 1023.
Okay, so how about we go to Trump? Last Friday, you kind of had a rant and thoughts about it. No, I'm just saying that now that the charges have taken place, it does seem to be split opinions out there. Robert Barnes had a righteous rant on Sunday.
Amazing rant. 50 minutes long.
Yeah.
550?
Yeah.
Oh, yeah. It's the best rant I've heard him do in a year.
He was running. Yeah, as the kids say, he was running wild on the streets.
But I'm not a lawyer. And so I don't know, is that accurate or not? Because I think, was it Jonathan Turley or somebody saying that, there's problems. I can tell you offline, Nate, the lawyer, saying, Trump's in deep trouble.
That's what Kurt thinks also.
Okay. So uncivil too.
Yeah.
Interesting.
Yeah.
Where do you stand, Joe? You're the arbiter of all Trump.
So you can look at, if you want to talk from a legal perspective, is he in trouble here? I think that the 31 charges based on him taking the documents, there's some deep legal issues with that, with those charges. Specifically, they charge him under 793E, which 7983E, the Espionage Act, is broken into different categories depending on the nature of the wrong. And 793E specifically is supposed to be dealing with someone who takes possession of the documents without right of authority, as opposed to 793D is someone who actually takes it under a right of authority, meaning if you take it and abscond with it after it was given to you, that's 793D, as opposed to 793E, which is applicable to situations where someone basically shoves them down his pants, like we had with the Sandy Berger case, where they're basically taking documents that they're not supposed to be taking in the first place. Those are two different statutes, they're two different charges. And the thought is that the reason they charged him under 793E rather than 793D is because there's a lot of influential case law from the Fourth Circuit, which covers in part Washington, D.C., which would be very favorable to Trump. So to circumvent that, they're trying to come under a color of 793E, which is not quite as vetted. So that's the argument that I've heard from other attorneys as to why it is, because it's a very strange thing. I mean, why would someone think that this is coming into his possession without him having a basis to have it in the first place? I mean, obviously, as president of the United States, when he's taking these documents, everyone realizes that he has the right to take it. So it's a very strange thing that Jack Smith decided to charge him on that. And I think that there are numerous problems with this case. I did a whole assessment in my locals with respect to people who bring up the Fourth Amendment issues, saying that none of these documents should be admissible because of the Fourth Amendment violations with respect to the raid on Mar-a-Lago. I actually, when I looked through that particular issue, I don't think that defense will be availing to Trump. I go through a lengthy, a 40-minute explanation as to why. But basically, I think that even though it probably should not have been, the raid on Mar-a-Lago should probably not have been authorized by the judge. Once the judge did authorize it, there's a good faith exception for cops. So, and that good faith exception will stop the normal remedy for a warrantless search, and will from turning the evidence into fruit of the poisonous tree. And so this evidence ultimately would still remain admissible. So the Fourth Amendment issues, I don't think he's going to prevail on. I think he has a stronger case with respect to the Sixth Amendment issues, wherein they really spend a lot of work coercing his attorneys to give up attorney-client work product and notes from meetings with Trump in ways that should shock the consciousness of every American out there. I had a pretty lengthy rant about this, and while there are exceptions
on that note, sorry to interrupt, but that I want to get in there. RFK knifed him pretty hard on that exact thing. I don't know if you saw. I think it was an interview on the Hill, or not the Hill, but with Crystal Ball and Sagar, and he actually cited that piercing the confidentiality implied a conspiracy between Trump and the lawyer, and because the judge allowed that it meant that Trump was in deep shit, if you will. And I'm kind of wondering, as a presidential candidate,
if you read the indictment, that's not what they're claiming happened. They're claiming that the attorney ultimately was duped. The attorney who was doing, in other words, if you just to give the factual underpinning here, what they're basically saying is it's funny that you're right. I mean, and if one of the exceptions to having the foundational protection of attorney-client privilege, which is essential if you're going to be maintaining Sixth Amendment rights. Sixth Amendment rights is right to counsel. If you have concerns, if you're a defendant in a case and you have concerns that you're going to ask basic questions that pretty much every criminal defendant is going to ask of their attorney, and and your questions are now going to become something that's subject to discovery by the prosecution, not just subject to discovery, but something they can actually throw in the indictment to imply guilt, that you're asking, well, what can we do here? What if the documents went missing? What if whatever? These are questions which every client, I mean, pretty much in a criminal defense case, is going to be asking their attorney to figure out, what are our options here? What happens with this? What if we do something a little shady? How would that's what from every criminal defense attorney I've spoken to, they field questions like that on a daily basis. That's
Andrea, we've got one here.
I mean, so Andrea, please confirm or deny what I'm saying.
Yeah, no, I mean, you're absolutely right. I mean, that's the point. Of course, as a criminal defense lawyer, you're not allowed to advocate illegal conduct. That's, kind of where that line is drawn on the crime fraud exception to attorney-client privilege. But if you don't have the lawyer implicated in, facilitating or advising, being complicit in criminal conduct, then yeah, that's a real problem for that type of communication to be getting exposed, because like you're saying, that's exactly why you have a criminal defense attorney, to be able to walk you through, what you need to do to protect yourself.
Right. So using his questions to his attorney as a way of trying to punish him is such a breach of everything foundational about our American judicial system that it's shocking. When I read that in the indictment, when I was reading it on air, I started losing it, because I think that this would terrify any criminal defendant, saying, how can I even communicate with my own attorney when my questions to my attorney may be used against me at some point in the future? Now, they're going to say that the state is going to claim that, well, because the documents were being turned over by the attorney, we had to verify that they were not working in cahoots with each other, because if they are working in conspiracy with each other, meaning if Trump was working in conjunction with his attorney for the purpose of trying to dupe the state into thinking that certain documents were not there or whatever it is, in that case, that would be a conspiracy, which would, they obviously claim to the judge, we have concerns that this lawyer, Trump's own lawyer, is working with Trump, so we need to get access to his notes in order to verify whether or not that's the case. Even if the judge granted that, which I think is a little bit of a stretch, because it's laced with all sorts of assumptions about what the attorney was doing.
Hold on, it's about to get heated.
Well, let me create some space so it can.
Okay,
right.
It's going to get heated. So somebody just popped their head in. They could not resist. So, Nate is here.
Beautiful.
Oh
no! I told you I'd stop by if I had some time. My car's still getting fixed, so
I know.
but
now you can talk about how Trump is doomed. That Jack Smith is a hero.
The walls are closing in.
The walls are closing in. So, take it away, Nate.
Another bomb.
Well, hey, listen. Only thing I can say is, I don't know if people have read this indictment. I'm surprised you guys are talking about this now, but I don't know if you guys have read the indictment, but I've written these things. I've made analysis of these things, and this one is pretty damn tight. The New York one is both BS. New York one is BS. This one, I think they got him, and I think a lot of the excuses a lot of our brothers in the law are trying to make are all nonsense, and it's Bill Barr, all the people who are in the know about these things will tell you this is not a laugher. Do I think Trump is? Do I think they're after Trump? Yes, I will say that, yes. But this is not a laugher. And if anybody's telling you this is a laugher, I think they either don't know what they're talking about or they just haven't read the indictment. Because this is serious.
So break it down for us. Tell us why it is serious.
Oh, all right. Look, well, first, I'll go with some of the major issues. Like some people will say things like the Presidential Records Act. The Presidential Records Act is the reason why Trump can't be in trouble. Well, the Presidential Records Act works like this. If the president is doing official things and he writes a note on a notepad, well, that could either be a presidential record because it was in the performance of his duties, or it could be something of his personal. And that's another example. Let's say a dignitary hands the president a bat and says, "This is for you and the people of the U.S." Is that his personal bat or is that a presidential record? So the Presidential Records Act distinguishes between those type of things. But what it doesn't distinguish with is things that are created and owned by the government itself. So if the president created the document, there's an issue. You can use the Presidential Records Act. But none of these documents we're talking about were created by the president. They were created by the officials in the government. So the Presidential Records Act is not even triggered in this situation. So anybody saying the Presidential Records Act applies to this case doesn't know what the Presidential Records Act is or what it actually does. So in this particular case, the Presidential Records Act doesn't save him from any of this. Number two, there's also another big misconception that everybody keeps saying, which is shocking because I even hear lawyers saying this, is that the president can declassify everything. That is wholly not true. So we all understand the president can declassify certain things, but he can only declassify things at a whim that are classified under his authority. Now that authority would be under the executive order, the last one that was actually updated by Barack Obama. So if we're talking about things that he executive order, he classified under that executive order, he can declassify. He has the power. But there are certain things that are classified under statutes. For instance, like nuclear secrets, military secrets, things of that nature. There's actually a statute, and they actually called something restricted data. Those things he cannot declassify by a whim. What he has to do is go through the procedure outlined in the statute to declassify it. So people saying that he can declassify anything he wants at will, that is false and misleading. Just look at the indictment and you'll see certain things he cannot declassify. So him saying I declassified everything does not save him. And then the third biggest thing is that for some reason people think that the president has that the documents, the military secrets, were his personal documents. That is not true. Anybody who works a job in America understands if there are things at your job, paperwork, and you take that paperwork home and then you quit or you're fired, that paperwork is not yours. That paperwork still belongs to the job. And that's exactly what happened here. That paperwork still belongs. So they didn't charge him actually initially with the secrets. They charged him with stealing government property. This is not your personal property. This is government property. And the last thing I want to mention is the whataboutism. What about Clinton? What about this? What about that? What about this? And maybe it's me coming from a police perspective, but it's like stopping somebody who's going 100 miles an hour on the street. And you stop them and they say, well, look at all these other people. Okay, well, I got you. Now, there is an argument about selective prosecution and all that. But if your argument is he's guilty, but why didn't they prosecute everybody else? Well, then what do you expect them to do? Just allow him to show military secrets to everybody? And I know you guys know about the tapes and everything. The fact that he said he didn't declassify them on tape, and all that stuff. So what I'm saying is, yes, I think there are issues with this case, but this is a very strong case. And if this was anybody else on the planet, they would be looking to cut a deal. But I think Trump is just trying to use the fact that a lot of people are defending him wholesale and don't really know what they're talking about. That's the reason why it's all up in the air. But Trump has an issue, people. And I hope people realize that.
All right. Does anybody else have thoughts? Joe.
Have you reviewed EO 13526 from Obama about classification?
Yes, that's the classification under his authority as president. It's an executive order. Yes.
Right. So you're claiming that he doesn't have the power to declassify, and I'm questioning on what basis. You're saying that if it's classification via statute, in that case, he wouldn't have the ability to declassify. First and foremost, I don't know that we know that a single one of these documents fall under that umbrella of documents that are classified by a statute rather than by some sub-agency under the direction ultimately of the chief boss being the president. So I'm not sure, when you have to cite me a statute and tell me that and also case law that says that Congress, because think about this from a constitutional perspective, on what basis would Congress have the opportunity to strip the president of the executive powers as to how these offices should be run? Because it's baffling to me from a constitutional perspective, the argument that there's a single document in Washington that the president is incapable of declassifying. Now, if you want to sit here and have an argument with me about what constitutes declassification by a president, we can discuss that as well. And I feel pretty confident in standing behind a very broad interpretation as to how he could declassify. But if you tell me that he's wholly incapable of declassifying certain documents, I question under what constitutional basis Congress could ever strip the president of that authority.
Well, just to be clear, maybe it's in Article 2 where it says the president can declassify and declassify. So I think that's an implied assumption that you're making, right? Because unless you can show me in the Constitution where it says he can wholly declassify anything he wants, right? So
he's the head of the executive branch. What do you mean? But they write laws. They don't carry out laws. Is classifying and declassifying now part of legislation, or is it the actual carrying out of law?
You're letting me respond to what you're saying. So again, like I was saying, so there are certain things that, yes, the president, under his authority, he can declassify, right? Because that authority, as you mentioned, was under the executive order. But there's other things like nuclear secrets that Congress said, well, no one is going to have the authority to declassify this on a whim. So we're going to make it a statute. I think it's called restricted data. You have to Google it. But there are certain elements like restricted data. I'm using that as a placeholder, but it's really nuclear secrets. Okay. Nuclear secrets cannot be declassified on a whim. There's a procedure, and it's written literally in the statute. So if you believe that statute is unconstitutional, that's an argument you got to make at trial. But as of right now, that statute's legit, and on top of that, he cannot just declassify those things at a whim. Even though I think this argument is a fruitless argument because he's already said he didn't classify any of this stuff. But
no. That's ridiculous. No, I'll talk to you about that statement.
Even accepting that he says he declassified it in his mind or whatever. The fact of the matter is he cannot declassify every single document and matter of fact, there was even a case. There's even a case. I should have had the citation ready where he went on television saying I declassified all this stuff, and then the news media went and said, okay, he said he declassified it. We won it through Freedom of Information Act. And then Trump's team said, no, he just said that. And just because he says it, there's a process for declassification. So in every which way you're talking about, but I want to hit the point, the one point that
you're modifying what you just, you're modifying what you said earlier. Because earlier you said there are certain documents that he's incapable of declassifying. Now you're modifying that to say that for certain documents there is a strict protocol for how he can declassify. That I'm not arguing on. I think I agree with you that for certain types of documents, I can understand that there would be a stricter protocol as to what steps he must take to declassify those documents versus other documents. So but I was arguing on a constitutional basis when you were saying there are some documents which are beyond his authority to declassify. I don't accept that as being a constitutionally valid perspective. However, if you tell me there are some documents which have a strict protocol that he failed to follow, that is a wholly different argument. And then we need to actually examine, okay, to which documents that actually were in his possession would those statutes apply, and did he fail to follow those protocols? But I don't know that there's a single document. I don't know if there's a single document which everyone keeps coming back to this whole nuclear codes thing. I don't know if there's a single document that actually falls under this rubric that you're trying to say is what sinks him, that he has an incapability of declassifying it, or there's a strict protocol. Are you aware of a specific document here that document, as opposed to being a letter from Obama, but that document actually is the nuclear codes that everyone has been terrified that he's been like handing to the Saudis or something?
Well, nuclear secrets is part of that restricted data, the way bombs work and all that stuff. But again, you would have to look it up. It's literally, I think it's called restricted data, but I'm not 100% sure. And the second thing, I want to address your point of the changing argument. I assume that there was an understanding here. When I say that the president can't wholesalely declassify something, what I'm saying is he can, things that are classified under executive authority, it's classified. He can classify everything right now that's under executive authority. Yes, but there are certain other things that are classified by statute that he can't do that for. He has to follow the procedure. So that's what I'm saying. Or the office. But it's listed, and I hold on, and I made sure I said it twice. It's listed in the statute. What you did was you said he couldn't statute it. So hold on. Let me respond. Let me respond to it. But I made sure in my little colloquy 5 minutes ago to say specifically that these things can be declassified based on the procedures in the statute. I said that before, but maybe you missed it. So go ahead.
Who determines the procedures?
And I wasn't trying to gotcha
Congress.
You. Nate, I wasn't trying to gotcha you. I never try to gotcha anybody in an argument. I don't think there's any point to trying to win an argument. I'm trying to search for truth. So I'm never trying to gotcha you or anybody when I'm arguing with you. I was trying to clarify your position. I think we now are both on the same page as far as understanding and in agreement that that it makes sense to say that certain documents would have a stricter protocol. So either you misspoke or I misunderstood you. We sorted that out. We're past that. My follow-up question though is, are you aware of a single document in this indictment that actually falls under that stricter declassification guideline?
Well, from what I'm understanding, the secrets about the capabilities, the nuclear capabilities, fall under that regime. But I would have to look back at the statute just to make sure, because the last time I looked at the statute, there were anything about development of nuclear materials, the use, the location, all that, like it's listed there. So, and I know Trump did have stuff about the nuclear, blah, 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 this. So I'm assuming some of that stuff falls within that category. But again, just look at it and we'll see what they're arguing. But I'm assuming they're going to be arguing nuclear secrets are protected under this statute. He had nuclear secrets. Show us that he followed the statute. If he didn't follow the statute, then it's still classified.
Okay. Well, I look. I'll be frank with you. While I went through the entire indictment, I did not go through the list of documents with a fine-tooth comb. So I'm not aware of any documents. I was really asking a factual question. Are there any documents that fall under that, which does undercut a lot of the arguments that are being made with respect to the fact that he has capacity to declassify? One of the things that I've argued with a lot of people on the left about is what steps, if we remove those documents, and let's assume for a moment that there are no documents which fall under the statute which require a heightened level of declassification, would you agree that it's not simply something in his mind, but it serves as a verbal act when a president at 8:00 in the morning on January 20th transports documents from the White House to a non-secured location, that serves as a verbal act that these are no longer classified documents?
Absolutely not. I think that argument's crazy. Because let's say the president has a nuclear code, and he's sitting at dinner with the Prime Minister of Japan, remember? And he leaves it there by accident. And then is that now declassified? That's why even if you go through the statute of procedures, it says things that are marked classified or treated as classified. And even if the statute says things that are marked classified. And that's what even their first subpoena said, things that are marked classified. Because if something is still marked classified, it's still treated that way. Now, you're saying that
you're talking about an accident. You're talking about
but how do I know this is not an accident?
Because it's ridiculous to say that he's packing up crates into an airplane, and that's an accident. He's accidentally packing documents into an airplane. That doesn't make any sense to me. By your argument, if he went through Central Park with classified documents and started, let's bring it to a Central Park situation. He takes classified documents and starts walking around handing them to people while he's still president. 2 years into his presidency, starts walking around handing them to random strangers. Do you not think that that's a verbal act of declassification?
No, if he's handing it to him, that's not a verbal act. That would
So now,
that's but I want to go back to the point that you just made before, where no, I think it is like the same thing, because it's not just about there is this implicit thing where if I do this, it automatically means it's classified. That's never happened before. But if that argument is making, if President Trump wants to break ground and make this new argument that he can declassify by throwing it out the window, then that's fine. But even let's say he did that. Let's take your situation as true. He threw the documents out the window. But as soon as they hit the floor, the law says because they're still marked, they still have to be treated as classified.
Where do you see that?
I'm still trying to imagine Trump packing anything, but don't want to interrupt you guys.
Yeah, that's true.
If he's directing someone to, if he didn't pack it, in that case, why is he the one? If he's not liable for the other people packing it, then why would he be chargeable in this case? Obviously, we're assuming that any actions he directs an underling to take are actions that, under a theory similar to respondeat superior, he's going to be held accountable for. And also, in the same vein, he would also be serving as an act to declassify. If he's directing someone take this box of documents from a secure place to a non-secure place, to me, that's a verbal act that's as express as him actually writing out saying these I'm declassifying or following whatever protocols are more typical. Now,
just moving them to an unsecure place, you say is declass. I think that's kind of crazy, Joe. But again, hey, you got to whatever saves his ass. But I don't think that's.
I'm not trying to say
moving the document.
No, what I'm saying is I'm trying to think logically here. I'm trying to think logically as to go ahead, Andrea.
Let me jump in and just ask sort of the counter example here. What specific words does he need to use to declassify them? Are there specific words he needs to use?
I declare bankruptcy.
Well, I would suspect if you have the highest secrets in the U.S. government, then the first thing you would do is tell somebody, right? You can't just, unless we're saying he can declassify him in his mind, and when he gets caught, then he can say, "Oh my God, I declassified him in my mind." So you're right. There may not be your magic words, but I'll ask you this: what about if he says, after he leaves office, "I wish I had declassified these things, but hey, they're still secret, and I shouldn't be showing it to you"? How much would that then change your mind to whether these things were declassified or not? Because they have him saying that on tape, showing those documents to other people.
Yeah, you see, and that is let me ask you this, Nate. Think about this for a second. If in fact he was waving like nuclear secrets in front of this guy, or any sort of classified documents in front of this guy, and saying, "Here, look at this," showing it to a non-classified person, and we have a DA that is looking to charge him on anything possible, and yet for one reason or another, the charge that they exclude is the very treasonous act of intentionally sharing confidential secrets with someone who is not cleared. Do you not think that Jack Smith would have incorporated that into the charging documents? They would be trying to literally have him get lethal injection for treason if in fact Jack Smith thought for a second that he was taking classified documents and sharing them with someone who's not secured personnel. Do you? I mean, that's common sense.
You must have didn't read the indictment, because that's like in the first couple of pages, right? They had the whole part where they had the whole part where he's talking to the reporters. They said we're going to tape it. They tape it, and that's when he said clearly, he said, "Oh, these are." He said, "I wish I can't declassify them now because I'm not president anymore." And we're supposed to pretend that he still classified them in his mind. He's literally telling people on tape, "I did not declassifar these." No, I don't know. Now, hold on.
Stop. You're totally wrong. You're totally wrong, Nate.
All right. What do you say in the document? Let me see if I can pull it up.
I'll explain to you why it is that you're totally wrong. Because if he's holding an article of the New Yorker, which is referencing classified documents, and he says that with respect to these classified documents that are referenced in this, that he says, "I could have declassified them, I didn't," that would explain why it is that he's saying, and maybe we can somehow. That would explain why it is that he's saying, I didn't declassify these documents referenced in the article, and now I can't declassify them anymore. And that would explain why it is that he's saying something so bizarre, which is like take a look at it, saying that he's actually showing someone who's not secured, and that would explain why Jack Smith didn't charge him, because Jack Smith knows that he did not, in fact, show any classified documents. That's why I asked the question to you. That's why I started saying, don't you think Jack Smith would have charged him with it? The reason he didn't is because Jack Smith knows that that's not what happened. But why did he put that in the indictment, which basically turns into some sort of lurid novel, which if you don't know that fact, everyone, including you, Nate, would walk away thinking that, like some jackass, he's taking classified documents and sharing them with non-secure personnel, because that is fodder for the media, it is fodder for the public, it is fodder to make everybody think that he is some sort of traitor to this country who doesn't care about our confidential secrets and is willing to expose us to the risks of our national defense. That's why I'm saying to you, the fact that he was not charged with it tells me factually that there was no classified documents in his hand that he's waving in front of him saying, I didn't declassify these. Here, look at them. I didn't declassify them. I can't declassify them anymore. That is not something he was charged with, because that did not happen. He's referencing classified documents. He's referencing an article which talks about classified documents which had never yet been declassified. So,
Joe, hold on. I just want to make it very clear. Joe, everything that you just made up sounds amazing. But let me just read.
It's not amazing. It's logical. It's logical as to why he wasn't charged.
By the way, Andrea started to say something. Please jump in really quickly.
No, we've long passed that station.
And Steve Gosney, how are you doing? And I think you're in absolute agreement with Nate, right?
I'm in absolute agreement with Joe.
Oh, okay.
Yes, Joe is 100% correct. The problem is that all of these issues, when you read this, all of these issues do not take into account the position of president as the leader of the Article 2 executive branch. So the first thing that needs to be, the first filter, the reason this is unprecedented and the reason this is such a malicious political prosecution is because he was the president and has the plenary power to declassify. Now, there are no nuclear documents. That has not been alleged, nor is that the FBI put that media out when they first released it. But that there are no nuclear codes type secrets that are referenced here. These are not. That is not what this is. But the question that I would have, and to kind of wrap your mind about it, and Andrea hit it kind of right on the money, is so we're saying that he could have declassified them with his plenary power, but he did not. And therefore, when he waved them around and said, look, classified documents, ha, 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 I took them out, didn't declassify them, and now, so he's basically setting himself up so that he can now brag, and now he could have done it, but because he didn't, then it's now a crime because he didn't declassify them. Okay, so my question is, to whom does he have to announce his decision to declassify to? As president, who does he go and tell that he has decided to declassify documents? Who is the person and who's the recipient of that notice?
Anyone on the planet, I believe. If he's saying something is declassified, he can't just declassify in his mind, right? He has to.
Why not? Yes,
other people have to. Other people can
yes,
know. But all right. So how would you know it's declassified?
He could do it through conduct.
How would he? All right. So how would anyone else know it's declassified? Because again, remember the law says if it's marked classified, you still have to treat it unless he changes the markings. But if they're marked classified, you still treat it as classified. Well, hold on. I want to hold on, Joe. I still want to address your point from earlier because
Nate,
I'm going to say it.
Nate, pull away from the microphone. Hold on. Pull away from the microphone. You've been killing people for a while.
Sorry. No, I'm over here waiting for my stupid car. But I want to bring up Joe's point.
And now he's taking it too far.
You're taking it too far.
Okay, well, there's a break. Can I ask a question? So, I mean, I would have assumed that Trump could have done it by conduct, because so over here we have the similar rules in relation to, and this is a long stretch of the bow, trade secrets. So anything and everything that is completely confidential information to an individual in a civil matter, if that information is passed on, irrespective of whether it's verbally or via conduct, whether or not you hand someone a piece of paper, if that is then passed on to a third party and it becomes what is effectively public knowledge known outside of the business or the company, that is no longer considered a trade secret. It is automatically, for lack of a better term, declassified by that company or the individual. Why would something similar not apply in this circumstance?
Nate, did you? I didn't tell you to disconnect.
The fact is that
I'm still here. Can you hear me?
Yeah, we hear you.
Oh,
now.
okay, good.
It's much better.
Yeah. All right. So let me just address this point.
Okay. Start addressing.
At Trump National Golf in Bedminster, New Jersey, during an audio-recorded meeting with a writer, publisher, and 2 members of it.
Oh boy. Nate, your signal's wonky.
Well, Joe, let's just leave it at you're right, and that's
That should be the.
I'm sorry, maybe my signal. But the thing is, but the only thing I want to say is, Joe made up this whole thing about him talking about an article and stuff. No, Trump actually showed them the documents and said that they weren't declassified. No, you said he was referencing an article and stuff.
How do you know that? How do you know that?
No, because it says in the indictment that you said you read. If you read the indictment, you would see it says. All right, so let me. So I'm going to read the part where they say he showed them the documents.
And the feds would never lie in an indictment.
Yes, I mean indictments are always true.
Yes, I believe everything they say as a criminal defense lawyer.
I mean, because that's what I tell my guys when they come into my office with an indictment, bro. You're guilty. Why bother?
And even if he did say that, it doesn't matter, because his declassification can happen by his action of removing the document from the premises. When he is president and he removes the documents, puts them in his box, says, these are for my library, his action alone is sufficient to declassify by act. It's a de facto declassification.
Even if he doesn't know it.
Once it's declassified, it's over. He has done it by action. For him to then come and say, look, secret documents, aren't I sexy? Doesn't matter, because it's already been, he cannot then reclassify something that's been declassified.
If we
he has no authority to classify it at the point of being out of office. He has the power at the time he is president, up until January 20th or whenever the swearing in goes, to declassify by act. And that's what he did
to bring that point home with the example I gave earlier, in that if he walks around Central Park handing out classified documents and thinks he's breaking the law, doesn't realize that it automatically serves as a declassification, it still serves as a declassification. You can have a declassification that the president is doing without even realizing that he is doing it. So
and all of the declassification procedures that exist apply to everybody except the president.
And there's a good reason for that. There's good reason for that, because when you take the reason there has to be a formal process for classification is because, think about this. You take a plain document and now you're going to say this is something we need to keep secret from enemies of the state or from whomever. Then it has to go into a vault. But when you're declassifying it, what you're basically saying is those things that are in the vault no longer need to stay in the vault. Is there a need for him to tell everyone take it out of the vault? No. If it just stays in the vault, and even though it doesn't any longer merit that type of protection, there's no harm to anyone. So that's why declassification does not need to be expressed to anyone other than the president, because if some underling there would base it, because that the president is the boss, he's the chief of the executive branch, he needs to know what's classified, what's not declassified, which is why he alone has that unique power, not the vice president, not anyone who's the head of the FDA, the DOJ, the FBI, the CIA, and these other triple letter agencies. None of them had that same authority, because ultimately they were all answerable to the president. But because the president,
Andrea had brought this point up, and her point was excellent. And that is, what are the magic words he's supposed to say? So is there a list of abracadabra? And there's a very famous example in the Bush administration when they were talking about Gulf War documents. There were very highly classified documents that were given out, that were being reviewed within the White House within the room, the little capsule, and he says I think it was he was talking to one of his major underlings, but like one of the cabinet members, and he gave the document to him and says, "Well, take that home and review it." And then the person says, "Well, this is classified. I can't take it out of this room." And Bush just points at it and says, now it's declassified. Here it is. He didn't have to do that. He didn't have to wave a magic wand and say abracadabra. The fact is I'm the president of the United States. Here's a document. I'm ordering you to take this home and review it. That is the act of declassification sufficient for that person to take that out of the room and do it. He doesn't there's no magic word that he needs to say. If there is a magic word, what is that? And what is the source of your authority for that magic word?
I want to make 2 points. Trump made this argument before because he said he told everybody he declassified a whole bunch of stuff, then went to court and said just because he said it didn't mean it was declassified. So you're right. So maybe there's no magic words, but saying they're declassified aren't the magic words because he made that argument in court. The second thing that we're talking about is what words does he need to say to make them declassified? Because it seems like even when he says on tape that he didn't, that he shows, again, because Joe said he was pointing to an article, but he wasn't. He showed them classified documents. Everybody wants to know, it's paragraph 6, section A, where it says that he actually showed and told people the documents and all that stuff. So Joe's saying that was an article.
But it's fleshed out.
That's incorrect. Well, hold on. But look at 6A. It says it right there.
Yeah, but I want
to go to the second point. I want to go to the second point. And you can respond. I just want to go to my second point is, it seems like he can say it's declassified and we got to pretend it's still declassified. But then when he says it's declassified, then we got to, so I understand we're all lawyers and we're all trying to stretch this in whatever way. But Trump himself, they have him on tape himself saying he didn't classify certain things. He's going to court saying that just because he said something was declassified on tape to everyone doesn't mean it's declassified. And now everybody's sitting here telling me that he declassifies it in his mind and tells no one, and that's supposed to be a reasonable interpretation. And we're talking about this implied declassification, which, again, this will be the first time in U.S. history that I think this goes in that way, where the president just classified in his mind, doesn't tell anybody. Again, this is going to be for the jury to decide, but I think Trump is in trouble, and I think these arguments are fallacious at best.
Not an issue of jury. This is a legal issue for a judge.
It will be a legal issue. Yeah, I agree.
Do you disagree that's a legal issue as to whether it's a verbal act?
Because he's going to be arguing that he declassified them. So I think that's going to be a matter of fact for the jury. He's going to say, I did it this way. The judge is going to make that ruling, but that's still going to be argued. You don't think the jury is going to?
Have you read the Clinton sock drawer case?
Yes. I have seen the Clinton sock drawer case.
So what is your interpretation of that?
Clinton, all right, as I made earlier, Clinton created the tapes. Clinton created those tapes. And then the tapes were wanted by the government.
So you're separating out the position of the executive from the underlings within the executive branch. You're saying that because
no, you asked me about the Clinton tapes. So I'm saying
right, but you're making the distinction that Clinton made his notes, but that because Trump's documents were not made by Trump personally, then that somehow distinguishes them?
That definitely distinguishes them. And the Presidential Records Act happens with the presidential's personal notes and things that are given to the president. But things that are produced by government and government officials do not belong to the president. The Presidential Records Act, I'm assuming, as you know, deals with the distinction between the personal property of the office holder of the president and the property belonging to the government that's taken in by the president or that he uses to execute his duties. That's what distinguishes the Presidential Records Act. But here we're not talking about documents that were created by the president, notes, or something that was given to him by a dignitary. We're talking about things that are created by the government for government purposes, and that's owned by the government.
The office of the president is not separate from the individual person of the president. I don't think that distinction holds at all. I think that the fact that the president is, or was at the time, Donald Trump, he is the personification. That means he has the absolute power of classification or declassification for all of his underlings within the executive branch. And so to say that there's a distinction there between some handwritten note that he makes from, say, the handwritten note that his secretary makes because it wasn't him, that you're trying to split the person from the office and the executive. This is why this is so problematic. It's a different case. It's not a traditional criminal case like Andrea or myself or you or Joe any of us would normally deal with, because we are not dealing with a traditional criminal. We are dealing with the head of the executive branch during this time in question. That is a unique position within the government, and things are different when you're the president. It is a powerful position. It's a very powerful position, and he answers to nobody under the Article 2.
I want to also push back on something else.
L'état, c'est moi.
Nate, you said something earlier with respect to selective enforcement. This is not a matter of selective enforcement because they're so rare. There's so few examples of someone who's in the position that Trump was in. In order to understand what is proper procedure under the law as applied to other presidents, it's important to look at how other presidents have been treated with respect to the way they handle documents post their administration. So when you want to, it's not a matter of saying, well, why are you punishing me for this when you didn't punish Obama for this? You didn't punish Clinton for this. You didn't punish Bush for this. It's not a matter of that his defense is, it's not a defense exclusively of like, oh, I'm being persecuted, which I admit would be a weak defense. It's far stronger than that, because you're basically saying, I understand what the statute says. When we look at how the government has enforced the statute with respect to presidents leaving office, the government has basically exhibited that this is a completely legal way and this completely compliant with the law. You can't change the way that you're applying the law now when there's only been 6 different people this law is applied to. And with respect to the first 5, you didn't apply it this way. But now all of a sudden you're going to start saying I should be thrown in jail for doing exactly what other presidents did.
And following up on that, I want to follow up on that. And do we all remember when James Comey came before the public and said no reasonable prosecutor would prosecute Hillary Clinton for having a private email server while she was Secretary of the State, not as president, secretary, and she had private emails, all kinds of things to deliberately avoid the Presidential Records Act and every other classification act, so she could conduct business and bribery outside of the zone of any kind of public scrutiny. And then she destroys that, smashes phones with hammers, and Comey himself, Mr. Ethics of the FBI, comes up and says, no reasonable prosecutor would ever prosecute this sort of crime. And she was the Secretary of State. She was not the president. And now we've got the President Trump, who takes some boxes for his presidential library of personal stuff. And it's like now he's Mr. Criminal number 1. It is clearly, the deep state is a thing. And the out of control DOJ and FBI is a thing. And this is exhibit number 1.
I think that's a bad argument, unfortunately. Because I think just like murder, not all murders are the same, right? Kyle Rittenhouse killed 3 people, but he didn't murder them, right?
Is that a bad? It may be a bad legal argument, but is it true?
Let me finish. Kyle Rittenhouse killed 3 people, and he was not guilty. We all screamed it. But there are other people who killed 3 people, and they're guiltiest and they're doing life in prison. So just because 2 people do a similar act doesn't mean legally it's exactly the same. So you're right. I would have prosecuted Clinton. I think Clinton, but that's a totally different situation.
Nate,
and we all know that there is context in each individual.
Clinton is a much worse situation.
Again, I've been sitting here letting you guys speak and getting you. So let me just get this point.
Wait a second. What about Southern law has been the one that's been interrupting everybody?
Can't get him to stop talking.
The
Final word from
Southern
law.
Perspective, Nate. The concern I have with that perspective is that it's one of the fundamental premises of our legal system that occasionally the guilty go free. And that is because it's so essential to preserve the fundamental structure, the basic liberties and so forth that our country stands for. So when you have this type of selective prosecution that, from my perspective, seems plainly evident, like it's not hard at all to see the double standard that's being applied, that implicates the fundamental rule of law, not men, principle that justifies us having a legal system where we put people in cages in the first place. So it is far, far more damaging, far more destructive to the basic civilization that we live in, to not be applying the rules equally than to let him go free, prosecute everybody. It doesn't matter. The point needs to be that fair is fair, and there are not animals that are more equal than other animals in our system. If we lose that, then, we got much bigger problems than,
But the response to that argument, that means Kyle Rittenhouse should be doing life in prison, right? Because if everyone who does something, murder, should be convicted, but there's nuance to it. But hold on, let me finish. There is nuance. There is nuance to all these things. So let's talk about the nuance in the Trump case. Trump was asked by the National Archives to turn over these documents. He refused. Then they went to a grand jury and got a subpoena. Then they gave statements, and they gave statements saying that, hey, we turned over everything under oath. Then they found out from a snitch in Trump's own camp that they didn't do it. Now you have somebody who's left office, who has all these secrets, that they believe are classified, that are still, matter of fact, marked classified. And the law says if they're marked classified, you treat them as classified. So then you get the subpoena, then you get the raid, right? Because he's now defied the subpoena. And now, if you read through the indictment, all the lawyers say, yeah, they were trying to hide the documents. They was asking us whether they should return them over and all that stuff. So now with all this, now you get to the end where they say, okay, we have to charge this guy because we've got all these things. And at any point, he could have given them back. And now at the end, we're saying it's the same thing as, well, why didn't they prosecute this person 12 years ago? Or why didn't they prosecute this guy 20 years ago? I just don't think that's I will agree. The New York case is 100% selective prosecution. If his name wasn't Trump, he would not be being prosecuted in New York. But this case, again, I'm with Bill Barr, I'm with Turley. They all see this case and all see the nuance in it and say this is a serious case.
Can I also jump on Andrea's point too, which is about the rule of law and about how this is much more damaging to the rule of law, not only for the unequal treatment of Democrats and Republicans, but it's also, this is a prosecution of the former president, who is the leading candidate for the opposition party to Biden, by the Biden Justice Department. This is not a special counsel. There's no separation. This is Biden, the current president, prosecuting his main contender for paperwork.
We got 6 ways to Sunday to get you.
And while saying that he has nothing to do with this.
Do the Democrats really want to put Trump in prison for the rest of his life? Because that's what they're saying they want to do. For this, which is not only selective, this is the most damaging, dangerous prosecution that this country has ever seen. This is a major constitutional crisis. And it is, and maybe my arguments may not be a legal defense, but they are surely a criticism of the prosecution as a political matter and as a lover of the country and the rule of law and the equal protection of law. This is an abuse, and this is something, as far as I'm concerned, they should burn the DOJ and the FBI to the ground and start over, salt the earth, because to me, the deep state does not run this country. The people run this country, and this is an attack on the individual sovereignty of our free country. That's how serious I believe this prosecution is.
Hold on. I'm going to jump in really quickly because I've got a bunch of super chats of people who want to get their points in. So let me go through these and I'm sure it'll cross. Let's go. Brandon saying Robert Gouveia would be begging to defer with Nate, I believe, on Trump being in legal jeopardy. And he agrees. Political prosecution jeopardy. This is a little different. Obviously, you guys have been saying that. The reason you can't prosecute New York Times for sharing Manning docs is that they didn't sign a clearance agreement. Do presidents sign clearance agreements? You'd have to argue espionage. I don't get the context on that one, but it must be the New York Times about the secret classification. What are the findings of Bill Clinton's classified docs case? That's if you didn't go after it, other guys.
To clarify, to answer that, the distinction that the left will make on that is that those were personal documents, and there is a difference. There is a difference in classification between presidential documents and personal documents. I've heard a lot of people make this point from the right, and I do think that there's a hole in this argument. And the reason, and that my point is, I'm trying constantly to search for truth, not to say Trump wins whatever. I'm trying to figure out what the law is based on what has been established so far. And I think that there is a fair distinction from the Judicial Watch case, which is the Clinton sock drawer, in the sense that they are personal documents and the president has a stronger hold on it. One of the things, there's so many different legal elements to break down on this case that we haven't even begun to discuss, like whether it actually even matters if he declassified it, or whether he still could, in theory, be held liable, even if they were properly declassified, which is what Jack Smith, I expect, is going to be arguing, that even if they're declassified, he still is liable. With respect to these acts, another element that I've never heard anyone talking about is this about that he has the physical documents? Because normally the Espionage Act is that you're stealing them from the government. The government doesn't have it anymore because it was written in 1917 when they didn't have computers where everything was on file. So it's not that you were simply taking it and having that access to the information yourself. It's that you were stripping the government of having access to those records because they didn't have photocopies of everything that was happening there. As opposed to now, whatever Trump took did nothing to impact the level of information the U.S. government had. It was not depriving them of anything because of the fact that everything is a computer file. They can just regenerate it all over again. And if he has a copy, and in that case, it's not hurting the government. There's the fact that obstruction, all these other elements require under the law a corrupt intent by the defendant in order for him to be held liable. You hear very few people talking about this, but in order for him to be held liable, you have to show there's a corrupt intent. Does an intent to keep it from the government qualify alone as a corrupt intent? Or does that actually mean that he has to have an intent to do something with these documents in order for it to qualify as a corrupt intent? These are legal questions which I don't feel as if the legal community has really been engaging in sufficiently in order to help better inform and enlighten the public, which I'd love to have discussions with you, Steve, or any of you on my show to talk to you about these legal questions about this case that I don't feel have been thoroughly vetted.
Well, and I would, somebody mentioned the Barnes, the Viva Barnes, and Barnes did, that was an epic 15-minute rant that he did.
50. It was really good. I would point people to that rant because, and I hadn't really followed Barnes that much. I've followed Viva because he's been on here a couple of times, and boy, I really liked the way he put it together in a very strong and coherent way. And I think Joe's point earlier too about the violation of the attorney-client privilege is, and sadly, I gotta say, I have seen that recently, even at the local state level, that you get this. There's a real prosecutorial desire to break down the walls of attorney-client privilege. We've seen it in our expert witnesses. They can't write reports. We can't consult with them. You've got to disclose. You've got to say these things. And this is a very dangerous thing for the right of people to have counsel. We have, thankfully, Andrea and I are both public defenders. You're a public defender, right? Mm-hmm. And so we have to advise our clients, and we know where the line is, right? You don't say, go destroy that gun or anything, but you have, but they want, you're there and you're trying to help them. You've got somebody who's sick, who's got a cancer, and you're trying to save their life. And, if they're prevented from telling you their symptoms, you can't help them. It is a nail in the coffin of the process that the Constitution is so desirous to protect. Most of the amendments of the Constitution, the Bill of Rights, are designed to protect criminal defendants. And if you can't talk with an attorney about it fairly and honestly without fear that it's all going to get disclosed, we might as well just start over. What is the new system that we all want to go to? What is it? Where are we going with this? Because once you lose these rights,
realpolitik, Steve. We are going to realpolitik.
So, Joe, another good point. I really agreed with you on that, and that's another avenue for which the whole thing could get thrown out.
All right, let me get through some more, folks. Project Com. Then any speech the president gives about nearly anything is an unauthorized release of classified information he learned from classified docs/meets. Yeah. Okay.
I don't know about that. Oh, just hold on. Just before you go, the people I've been arguing inside the Pep Boy, and the people in here agree with you guys. So I hate you people.
So who agree? Is it majorities at Minnie, Mo, and Jack, or just Minnie and Mo?
No. There's three of us, so they have to put you guys on speaker when you guys speak. So they really like Joe and Andrea. And then, so early when I was like I was speaking to them, and then they said this other guy, I don't agree with him, but he's making good points. But they're like, why don't then they just ask me why I hate Trump? So I'm like, I don't hate the guy. What do you mean? So anyway, that's what I'm going through right now.
All right. There is a formal declassification that includes making redactions, going through all the agencies for comments, etc. He can use it, not must use it. I think that's the point everybody's making, or not everybody, but many of you, that it's his thing. He could change the rules at that point. Then every speech given by a president, ladies and gentlemen, I formally declassify all the information I'm about to present using my Article 2 power.
Yeah, exactly.
Well,
he wouldn't do that.
Well,
he's
he
saying that,
said
like,
that.
if he makes some statement, I mean, let's just say, so the president says something and accidentally lets slip something he learned in a classified setting. Do we now prosecute him?
No, of course not.
Think
Of
about
course not. He has sovereign immunity. Of course not. But the thing is that this has already been litigated before, where he stood on stage as president, said, I declassified all this. And then the news media went and said, okay, you declassified it. Now we're running freedom of information. And guess what President Trump said? Well, just because I said it doesn't mean it's declassified. There's a process. So, while we have this conjecture, while we have this conjecture, I have case law where the president says, yeah, even though I said it in a room full of people, doesn't mean it's declassified. That's what he said.
Okay, so a couple of things. First of all, if you think about philosophically, how different would any of the facts here actually be if instead of just putting on the plane, he actually wrote down the words, I hereby declassify everything that goes on the plane? Would that all of a sudden now say, oh, okay, now you can't charge him? Does that make sense to you? That if he just writes that down on a piece of paper while he's at 8 in the morning, while the plane is being loaded, every document that gets loaded on the plane is hereby declassified. Now everything's kosher. But because he doesn't write those 6 words down, all of a sudden now we're thrown in jail for 400 years. Does that make any logical sense to you?
No, but what would make logical sense to me? If he got in the plane with all those documents, then showed people why he's president, he can do that, right? But then eventually the plane lands and he's not president anymore, and he takes those documents to his house and then shows other people and says, hey, I wish I'd declassified these as president, but I didn't. But look at them anyway. Then he should. I think he may be holding himself up to be classified. So you're right. In your situation, which didn't happen, I agree with you. But in the situation here, I think they got a case.
So okay, hold on. So another super chat with 2 ridiculous hypotheticals that just went by. Anyway, I'm amazed that you want to even give one person that amount of power over here. That is only matched by royalty.
That's the DACA case. Power. The Supreme Court gave Obama that level of power with the DACA decision.
Yeah, and actually, when the Constitution was being written,
he was going to be king.
One of the big things, one of the big criticisms of the federal government was the presidential power, the power of concentration. There was a lot of criticism in the founding of the Constitution about what's this president point. It seems like that's a lot of power in one man. So that's a valid criticism.
True. Let's go, Brandon. I told
Chandler
there's
one factual thing I want to throw out there just so everyone is aware. Document 19 on the list of documents is the only one, but it would in theory support what if Nate is correct, it could. It's the only one out of the 30 documents that could classify as, based on its listing, where it says undated documents concerning nuclear weaponry of the United States. All the other documents, so first and foremost, I want to say all the other documents that are listed there are about the weaponry or capabilities of other countries, which would not be American nuclear secrets. Document 19 does say undated document concerning nuclear weaponry of the United States, but I don't think that just because it's labeled that necessarily all qualifies it as something that falls under it, because I don't think as soon as they use the word nuclear or talk or say anything about nuclear weapons, that all of a sudden goes into some special heightened vault that now requires special protocols. It would certainly depend on the nature of what is written in that document in order for it to be, assuming Nate is correct, which his argument is logical, that certain documents would have a higher level procedure, we would need to know more about document 19 in order to know whether or not that would require higher scrutiny. Just because it's labeled as being nuclear weaponry of the United States, that doesn't tell us what's in there. If it basically says something as inane as, we have nuclear weapons, obviously everyone would realize that doesn't mean it also gets heightened classification. It depends on the nature of what's in there, although that certainly seems to be the most difficult document to justify from Team Trump with respect to that being just something that gets thrown around willy-nilly. And it's certainly in the eyes of the court of public opinion is something that's going to be fodder for the left
And
to
don't
attack
the
him.
nuclear codes change? Is it like if I had
I'm sure it changed 10 seconds after he was sworn in. I'm sure
Exactly.
No, it changes.
So
It changes while he's in office. I mean, let's be honest.
it
It changes every so often. Even his probably changes. Most likely, I got to get
remember
these
when
guys that
Clinton
show
lost nuclear football. He
Guys.
left it behind.
Yeah,
Mhm.
guys,
I remember that.
I'm running way over, and I'm about to have construction going down on my house. So let me go ahead and get through the super chats. I apologize completely because I know this is hot and fun, but Chandler, I'm 8 foot. Is that stand in court? I'm not sure the context of this whatsoever, but Chandler,
he can say whatever he wants after the fact. It's just because he says it, it's true.
okay.
Yeah.
All the older CIA guys, look, kids, I have a crazy guy looking to get points with Eva Longoria with a rifle standing by. Let the old ways work.
Yeah, I don't think so.
Okay. Sometimes I just don't get it, and so it could be context. Preston Park, whataboutism equals rule of law in case someone tries to use the term as an argument.
Right. It's called equal protection under the law. Ask if you think it's only Trump that the deep state's after, ask some January 6 people about that equal treatment under the law. It's all of us. It's the people that are being targeted by these deep staters. So I'm very much concerned where our country's headed.
Okay, now I have 3 Rumble rants that I'm going to go through, and then I'm going to be wrapping up just to let everybody know. Judge Berman Jackson found in the Clinton Sox case that the mere act of taking the tapes from the White House inherently designated those paper records as personal, QED. NARA is not a superior authority to the president under Article 2.
Yeah, exactly. Yeah. That's personal because they said he created them, and the who decided was president. Presidential records are personal. Clinton decided, and he said these are personal. So by the act of taking them away, they're personal. But that's for presidential records specifically, though, not government property.
All right, and Ghazi, I was hoping you would show up. This one just came in, so good to see you. And then one more, I want to ask Nate a question.
Me. Nate is trolling me. That's what he's doing. He's picking on me. I saw Joe was doing such a good job defending me that defending my position, but I don't know. I had to come on and throw my nose support, Nate. I'm not with you on this one today, Nate. We're on the opposite sides of the fence.
All right,
you know what?
I got another rant. Let me do it, please. Sorry. I want to ask Nate a question. What statute may be written above the authority of a constitutional provision? Mm-hmm. And that is the last rant. What statute, Nate, may be above the authority of a constitutional provision is the question.
Zero.
Oh, okay.
Zero. Sorry, zero. I got a call with the
So then
absolutely none.
Okay, so then the argument is that because it was his department, everything else, and he was in office at the time, that he took it, that he had every right to do whatever the hell he wanted, and that kind of goes right back to the Barnes thesis, I believe.
Yeah, but Barnes is horribly wrong. Well, if I want to talk to Attorney General Barr, he'll tell you exactly why Barnes is wrong. But the key point is that these are government documents, government records. So these aren't personal records.
Government is Article 2. Government is the Constitution. The government is not something separate from the Constitution. The government is subservient to the Constitution. Yeah, Article 2, every department of every agency is under Article 2. So that is it's artificial to say the government is over here and the Constitution and the president's over here. No, the whole government is founded on our Constitution.
Yeah, that's not the point I was making. The point I was making is because of the property, personal property, and government property, right? Trump has personal property, but there's some of that property that happen to belong to the government. The secrets and stuff that actually belongs to the government. That's not his personal.
But who is the government?
You would agree with that, right? The government, when Trump was in office, he was the government
property.
It doesn't belong to him personally, but it belongs to him as the agent, the top guy under Article 2. It's his government.
Okay, so just so I can put this to bed, right now I have a job working at a bank. I have documents. While I'm working at the bank, I can do whatever I want with those documents if I'm president of the bank. If I resign or get fired and I take those documents home,
you're speaking as an employee. You're an employee, though. There's a difference.
But
You're
so is
acting
Trump.
as the employee.
Trump is the
And you
employee of
don't
the
have
government.
plenary power
No,
That's why he
because you
gets
have to
paid.
answer to the banking administration.
Yes, but
The laws are
when
totally.
I leave my job, I don't have that power. So when Trump left his job, he doesn't have that authority to do whatever he wants with those documents.
A better example for you, Nate.
Nate,
I'm helping you. I'm helping you, Nate.
and why he
Nate,
was
I'm
president.
helping you. Nate, I'll help you. A better example is O'Keefe in Project Veritas. That you're saying that he's answerable to the board ultimately. That's what essentially that's a better analogy than just some banking official, right? He's the founder.
We all know. Let's just cut the BS. We all know there's things that belong to a job and things belong to you personally. Those documents didn't belong to Trump when he was working there. When he was the president, he was getting a salary to do it. Yes, he could do whatever he wants with those documents. We're talking about what he was doing with the documents afterwards. They didn't belong to him. They belong to the government, and they asked for them back. I understand.
When did he take the documents?
But that's simply. It doesn't matter if you take the documents while you're employed and then you get fired or lose and then you keep the documents for a year later.
Well, no,
they're
that was
still
part
not
of your
your
argument.
document.
That was
And
part of
his
your argument,
document.
Nate, because part of your argument was when you take the documents. You were saying that if you took the documents after you were done working at the bank, that would be something. But the thing is that he was still president when he took those documents. So I think that was to,
he turns 30 and turns into a genius.
Maybe I have to clarify. Even if he took the documents a year while he was in the presidency, lost the presidency, and still has the documents, those documents are not his. They still belong to the government. So if just in case anybody wants this in clarification, if he had the documents while he was president, he could do whatever he wants. But if he still retains those documents after January 20th at 12 o'clock, as the indictment says, those documents are supposed to be returned back to the place of employment, which was the thing. So he does not own those documents. Anybody who's making that argument, there's nothing I can tell you. That's just essentially common sense.
but he
doesn't own those
classified them
I'm
by the
going
act of taking them.
Right.
I think.
And I think we're at a complete impasse on that argument. I mean, I really think it's
Eric wants to go. Eric wants to go.
I have to. No, I have to go. And I want to put it out to the audience. Seriously, comment below. I'm going to cut this clip out. I hope everybody really does share it. It is a nice heated debate, but I do actually have to go. I apologize, but there is an impasse. We're not budging on it. Nate is saying he doesn't have the right. Once the office ends, he loses possession of everything he ever had. And you are saying, no, he had the possession of it. It became his property. And if he took his property when he left, he took his property with him. Those are the two arguments that I'm hearing. And nobody is budging from either side. So I think that's probably going to have to be settled out by the
Nate.
wisdom.
I still love you, brother.
Props
my
to Nate for being the
commentary.
only seeming leftist on the panel. That's not an ezy task. That's not an easy position to be in.
And
Hey,
the reason
you
I'm telling
can
you
go
I
now.
still love you is to show I can still be merciful in victory. So
Yes.
Hey, listen. You know what? I will say this. I think everybody in the comment section is going to agree. But again, I don't tell people what I think. What I think they want to hear. I tell them how I feel. That's why I was able to say Rittenhouse is right. That's why I'm able to say I think Trump is wrong here. But again, we disagree, and this will make these panels fun. The fact that we can disagree and we can still be friends. I'll be on your show yelling at you probably tomorrow night, Joe. So it just is what it is.
yeah.
And that makes it the best. So in keeping with the tradition of the show, Joe, take us out with some wisdom.
Oh, everyone know. So make sure you sign up to Southern Law and Andrea Burkhart, Aussie Overlord, Steve Gosney, Chandler Remington, this panel, and Rob as well as Nate the lawyer. Phenomenal people. Also in civil, he was in the chat contributing here. Don't forget to sub up to him. And yeah, if you want to hear more dissection of legal legal cases, particularly involving politicians like Biden or Trump, I urge you to check out me on YouTube or goodlogic.locals.com. And the last point that I want to make, and that's probably the most important thing out of everything I've said so far today,